Lordship, I beg to mention for listing my lord on Monday. My lord.
What is the urgency?
Lordship, in this matter, my lord, is since 2016, my lord, it is pending. The matter is collection appointment.
Okay. Really?
May please your lordship. Lordship, I beg to mention for item number 28 of today's daily list. With the consent of the petitioner side, lordship, I pray for passover of the matter, lordship.
Given what item?
Item
Why?
28.
Why?
Lordship, Lordship, my senior was about to appear, but due to some difficulties, he could not appear.
On a prayer made on behalf of Mr. P. Purkhasto?
No.
Lordship, we are for the respondent. He is the
Okay.
petitioner.
Who? N. Bora.
And Bora, lordship, on behalf of N. Bora.
On the prayer made on behalf of Mr. N. Bora, who is said
A
to
date
have,
may be given, my lord.
who is said to have some personal difficulty appearing before the school. Okay, comma. List this matters again
Lordship,
on
on 12th of February, possibly.
12 to 2024.
Already covered, my lord.
I've seen.
Obliged.
My lord, one IA was filed, my lord, for correction of the order, my lord. On
Oh,
24th it was filed.
Get it on Monday.
Monday.
5 to.
Well, another matter, my lord, similar petition has been disposed of, my lord. That may also come up Monday. Well, public.
Silo, whatever. He is very good, basic tech, right?
Your lordship, I beg to mention for an urgent listing of a WPC for today, your lordship.
What is the urgency?
Your lordship, an advertisement dated on December 26 was published, according to which certain assistant teachers and MIL teachers were to be appointed, and it was published online. And the petitioner is also a candidate who can apply, who is unable to submit her form online because of a certain clause mentioned in the advertisement.
What is the clause?
Your lordship, in the clause, it is mentioned that the applicant should have MIL, the lingual as their HSLC's subject, or they should have a diploma in that subject. Lordship, the candidate does have a diploma, but she is unable to submit her application online.
Why?
Tomorrow is the last date, your lordship.
Why, Mr. Why the applications are not being able to be submitted? Okay, get it. We'll see.
Yes,
We'll see. If that is the issue, we will see. Don't worry. Get it.
Copy to Diva.
You are otherwise eligible.
Yes,
Only
your
thing is
lordship.
that you are not being able to submit your application
Yes,
online.
Yes, your
Okay, Mr. You give a copy to Mr. Chisti immediately. 2 o'clock.
May I please, your lordship? Lord, I beg to mention for listing of a matter for tomorrow.
Why? What is the urgency?
Urgency that, Lord, I have come against the suspension order. my lord.
Okay. Suspension order. Enjoy your paid vacation for some more time. We'll have it on 7th.
The person is about to be retired.
When? Retiring
in the
when?
month of August.
August. Enough time. We'll
Alright.
see it on 7th. When was he suspended?
Was suspended on 3/1/2023.
3/1/23. Until now, you had told me this, I would have put it back again. I mean, 7th. Yes, madam.
Sir, Lordship, I beg to mention this contempt petition for listing for withdrawal. May I please, your Lordship, I beg to mention a WPC on Monday, your Lordship.
Monday.
Yes, sir.
May I please, Your Honor, I am also prepared for listing a matter for Monday, lordship. Obliged.
May please, your Lordship, I beg to mention item number 29 of today's list. And the matter may pass over for the day.
Contempt matter, madam.
Contempt.
Be here. Mr. Chisti was to receive some instructions. Be here. We'll see what it is. What instructions he has got. We'll see. Contempt matter. You have brought it to my notice.
Actually, a petition was not available with me. So
Petition is not with you. Don't worry. I'll help you. I'll help you. You be here. Yes.
my lord, this may be listed tomorrow, my lord. It's very urgent, matter.
What is the urgency, madam?
This is, my lord, regarding amalgamation, wrongly amalgamated school, my lord. 1944, my lord.
Give
Established.
it. Tell me.
Tomorrow, my lord.
Only the order is not very old, I suppose.
My lord.
Order is recent.
Recent, my lord. But thing is that, my lord, already they have planned to demolish the school, which is established in 1944, my
We'll see.
lord.
But did it. Madam.
Supplementary list for motion item 41
Losses here.
as first
Yes,
item.
it means AJ will appear loss in the can take it up.
Okay, whenever it's convenient. There are a few other matters also pertaining
Yes.
to that list.
Yes, yes.
Okay, whenever it's
All
convenient.
the three matters.
Ah.
Yes. And in
We'll go and then we'll reach.
Yes.
You tell me whenever.
Yes.
And get the petitioners also.
Yes.
Okay. No, matter, matter.
For delivery of order item 1,
That way, Mr. AG will appear. We'll take it up after some time.
Good.
Delivery of orders, Mr. Doctor, we have done. We'll pass the orders in the second half. We'll pass the orders in the second half. If you are here, fine. Otherwise, we have already noted. We will just dictate. And we are, tell Mr. Nath, we are interfering with your order and directing for a review by the state selection board in his case. If he fulfills, then from that day, give him the because he was holding the charge. None, item number 2.
item 2 to 4,
You are appearing for the,
WBC number.
no, you are appearing for the headmaster.
Yes, my lord.
Just give me one clarification. Otherwise, we are ready. One clarification is required. If you come to this order at page, the DSC minutes, Madam Jain, you also just have a look at page 24. Right? Wherein you have been denoted as a language teacher with headmaster. And that is in tune with the proposal or the particulars you submitted on 3/6/2017, right? You are not disputing this document at page 24 and 25 of WPC number 5421. You cannot because you are relying on that in your writ petition.
My lord.
You have not disputed that in your writ petition. 5421.
54.
He has not disputed it, madam. No. Come to page 24 and 25. That would be in your writ petition.
And it was latest was filed, my lord. My lord.
No,
Earlier, my
latest
lord-
was brought in by her.
My lord, earlier both the Tuesday I filed my.
No. Only thing I want to know is if you then proceed further, page 24, 25, 26, you have seen.
My lord,
5421.
my lord, I submit my all the documents, my lord.
No, in your writ petition.
WBC, my lord.
WPC 5421.
54.
Madam, give him a copy of 54.
You just my
Just have it. Just have it. 5421, you have it?
yes, my lord.
Come to page 25. You got it?
Yes, my lord.
Now here your name is shown as headmaster language.
My lord, my yes,
No problem.
Yes.
Are you disputing this document?
yes, dispute it here, my lord.
You're disputing?
Yes,
Come to your writ petition. 484686.
my lord. My humble, that is the initial, my lord.
We are not on
Subsequently,
that.
my lord.
I'm on a different question altogether. You come to page 10. That is your statement.
10.
Para 12,
Yes, my lord.
right? This is the statement with regard to annexing that, the one I showed you now.
Yes, my lord.
You have not disputed this.
My question is that, my lord.
Okay, I got it. Your question will come. First, hear my question. My
Yes.
doubt you clear.
Yes, my lord.
Now, if you come back to 5421 again, page 29,
5421, my lord.
page 29.
It's 29, my lord. 29.
This is the second minutes of the district committee. Right? You got it? Here, your name comes as social studies teacher. What was the necessity of bringing it back to the district scrutiny committee
lord,
again?
My lord, my humble submission that when this earlier district should be submitted before the director, my lord. Director remand this all the matter, my lord, to the district level registrar.
Okay.
For fresh, and there are no signature, first 2 pages, my lord. And so subsequently, recommendation, this is authenticity of.
There is a signature
Yes,
in,
my lord,
in the last page.
My submit, my lord, that part.
You have not disputed this, Mr. Counsel. You have not disputed this.
Neither
No,
they
no.
will
And
be
do you dispute page 28? Page 28. This is the form given by you. Do you dispute this?
Yes, my lord.
This one?
20, my lord, 20, subject matter, my lord.
No. You gave it. Azibur Rahman.
It is to only, my lord, particular 1 year. Subsequently, on the dashboard, my lord, that was.
No. This is the educational qualification for provincialization. Why? What was the material before the DSE subsequently to come to a contrary conclusion? You have not disclosed that. Did you give a fresh proposal or a fresh particulars?
That is the direction directed by the.
Where is it?
My lord, I submit, my lord, the report already. Sensitive report, my lord, I have submitted. Already, I submitted all the document, my lord, also.
No. I just want to know from the records where it is. It is not there on records.
That is, no, subsequently, I submit, my lord.
You submitted in that bunch.
Yes, my lord.
No, where is it in the records?
It is submitted by the, my lord, report, my lord, my additional affidavit, my lord. All the additional affidavit, my lord. Earlier, there was not signature. So that was remarked. Subsequently, this.
I got it, mister. I got it. And this I know.
Yes, my lord.
No, but why did change?
My lord, as per my lord, direction of the director, my lord.
Signature. See, page 24, 25, you have not disputed. That particulars correspondence to your list. Now, when they comes back for signatures, why this change had
And my lord, the director also, my lord.
He does not say anything more than that signature part.
Yes, my lord, director report, my lord.
Signature is not there.
Yes, my lord. And subsequently, my lord, the director directed the deputy commissioner to file a fresh recommendation, my lord.
Fine. What is the basis for that fresh recommendation?
There is no signature first.
Only that?
Yes,
Only
my
that?
lord.
And this 24, 25, you are not disputing because you have also relied on it. But tell me, why this change in page, this page 24, 25 and page 29? What is the basis? 25 and page 30. What is the basis?
25, my lord, WC.
WPC 5421. Yes, Mr. Bora. Why this discrepancy?
Here, my lord,
If Lordship
initially
permits
the
me, I
list
can give the explanation.
Mm.
If Lordship will peruse that page number 24 and 25, where the name of the respondent is mentioned as headmaster, there Lordship will observe there are 2 language teachers.
I know that.
And
I
the
know that.
second
No, I
language
just
teacher
want to know.
whose service is in provincial.
I got to know that is your stand before this court.
Yes, your lord.
Now, what is the material before this DSC when it came back only for the purpose of signatures?
No explanation in that
No.
regard has been mentioned, your lordship.
It's no there. No explanation is
No
there, Mr.
explanation.
my lord.
No explanation is there.
Initially, the list submitted by the district scrutiny committee,
List submitted by the principal, headmaster,
my lord.
was accepted by the
Deputy
District
Commissioner,
Scrutiny Committee.
District Scrutiny.
Then why this change in page 29?
That list
30.
submitted by the district scrutiny committee before the SLC. my lord.
SLC, it came back because there was no signature.
My lord,
Subsequently, when it came back
Subsequent-
only for the signature purpose,
my lord.
how could this be changed?
My lord, that
The
change,
whole CDETM has been changed.
my lord, that
What is
was
the
made by
material?
the deputy commissioner. My lord.
What is the material?
My lord, that instruction.
Have your instructions. Have your instructions.
My lord,
Okay?
my lord.
We'll have it on 7th. I'm otherwise ready. When I was going through it, this discrepancy came to my notice. This letter, I've seen it. It's
Yes.
only for signature.
No, my lord, second recommendation also there.
I got it. How can you
And-
change that
And
recommendation?
my lord, the director filed the affidavit, my lord, and that's affidavit only 3 posts is required, my lord. On the basis of the.
I got it.
that might be
I got it.
considered.
I have the affidavit with me. In the second, first case filed by her, the affidavit is there.
Yes, sir.
The Mr. P.K. Bora shall on the next date fixed bring on record the reasons as to why the DSC, which had initially met and the recommendations of which are available at page 24 to 26, had recommended the respondent number 6 herein as a language teacher along with the projection that he is the headmaster, and the petitioner herein as the social studies with the projection that he is an assistant teacher, was required to be changed in the subsequent recommendation as available at page 29 to 31, with the respondent number 6 now being denoted as a social studies teacher and the petitioner being shown as not eligible for provincialization. The said instructions shall be in written form, shall be placed on the next day. List this matter again on 8/2/2024.
My lord.
Also, the delivery of orders is deferred
8 to 9.
and would be so considered after
My lord.
the receipt
My lord.
of this said instruction.
9, my lord. 8, my lord, some problem.
If you have problem, 7th? 7. 7 total.
Deeply obliged.
Obliged.
And today's item 20 and 21, same issue, same issue. Today's item 20. we have a record.
Same party.
Party is different, but the issue is same. That the two.
I don't find it. I don't find any reason. Or they have taken time. 28, they have taken time.
2021. 20 and 21.
20 and 21. Abul Hussain, yes. I've seen it. We'll consider that. We'll consider it. Yes.
AGS.
AG is here.
Yes.
Call it.
না, মই কৈ দিছো কথাটো।
Item 41.
Yes, Mr. Sukya.
Lordship, we have revisited the directorate as well as the government, and there was an inadvertent mistake.
Yes.
So we have rectified it, and today Rafik would like to file an affidavit. We are going to add in the eligibility criteria graduation with 2 years diploma in elementary education. That is number 1. And number 2, the last date is 2nd, so we are extending it to 12th.
Okay, fine.
If Lordship would direct, then we can file a short affidavit,
No,
or
this
otherwise,
is
Lordship,
enough.
please to
Mr.
close it off.
We have said this, that is enough. So can I record that?
Yes,
it
yes,
will be
Lordship, that can be
extended till
recorded, and
12th?
there is a written instruction.
I've given.
Yes.
So,
They are asking Lordship that graduation with 50% with at least and bachelor's ED. That is not here in the original notification.
that's not there.
That 50% is not
Not there. It is only graduation,
with 2 years BEd.
DLED. And 50% will come in if you have Bachelor of Education,
Yes, the others,
Ah.
the alternative.
alternative.
Right.
college. But this graduation with 2-year diploma is already there. That was somehow missed out.
Yes, Lordship, that 2011 and 10.
Okay. We'll pass orders.
Lordship.
We'll pass orders.
Lordship, the only thing is that you lordship, because we need to apply through online, you lordship. Whether it is
They are
applied-
extending it till 12th.
12.
AG is saying, why are you apprehensive?
So,
Obliged.
and time also we have fixed
We have
12
fixed it. I'll record this and
Yes.
then dispose it of.
till 10 PM of 12 February.
I'll dispose it of. The second half you'll get it.
Deeply obliged.
Much obliged.
Should tell you. What's like-
Explain.
Well, yeah, they do. Only second half of time.
Meeting করতে।
That material. Hey, that was a material.
Item 1,
It online as no, one, no,
not 1.
not one. Item number
42.
42, 43.
May I please?
Item number 42 and 43.
May I
Yes,
please? This is a challenge to the advertisement of the Department of Elementary Education, which is inviting applications to teachers' vacancies. and they have non-suited those with who have an 18-month diploma from the NIOS under the MHRD direction. The Lordship is probably aware of all of that. Now, my lords, the reliance is on a Supreme Court. Can your Lordships hear me, my lords?
Yeah. Loud and clear.
Yeah. The reliance is on a Supreme Court judgment, and my lords, on the basis of which this non-suiting has happened. Now, my lords, my submissions are, I have 3 submissions which are independent and alternate. The first is that it's a complete misreading of the Supreme Court judgment to say that the 18 months course has been de-recognized, because the Supreme Court judgment, and I will take a Lordship's way, very clearly says that this is a one-time window of opportunity for in-service teachers, for which the second proviso to section 23 subsection 2 was brought about, and to give them the minimum qualification in terms of section 23. So once, my lords, I am qualified, the question therefore of my being non-suited is not does not arise. And the court also, Supreme Court also said that these will not apply to fresh applications. So basically, all those who were in service in 2015-17, whenever the amendment came into force, and if they had acquired that 18-month diploma, would be at par with the rest, and therefore acquires qualification under section 23. Well, that's one. 2, my lords, the judgment also in terms of equivalence. Now, because the second submission, it says that there's a finding of the court, and correctly so in the case of, because in the case of Uttarakhand, they have the court was considering the matter, there was a 2-year stipulation. The court said that there can be no equivalence when the rule says 2 years, and you cannot therefore have an equivalence in 18 months. But it also showed the way when we was in paragraph 51, the court says that all that it is required is for the NCT, who respondent number 4 before your Lordship, is to issue a circular under section 23(1) saying that 18-month course is also applicable. And I would submit, my lords, that NCT already having issued a regulation under the NCT Act saying that the 18-month course is a valid one. All that it is required, my lords, that a mandamus can be issued to them, because it is already their stated stand that they can issue, if the need arises, to issue a circular superseding that 2 years and saying that 18 months is also applicable. And
That's
thirdly, my
basically
lords,
your projected case.
yes.
That's
And
your
third,
projected case.
yeah, projected in the pleading, but my lords, on a careful reading of the judgment.
Mr. Hazarika, can I
Yeah.
just, some queries, if I can
Please.
just ask. The scheme of things that was there in that 18 months course was limited to the in-service teachers,
Absolutely.
to make them at par with the qualifications under the RTE Act.
Absolutely.
Then the regulations of NCT, which was holding the field 10, 12, 14, were never corrected or were never amended. It continued to have that 2-year prescription. I have failed to find out, that's what I want from you. I failed to find out a notification from or a decision of the NCT saying that these 2 qualifications are the same. Now, this equivalence came to be declared by the Patna High Court, right? Followed by the Tripura High Court. So, beyond these 2 judgments, is there an independent decision of the NCT that these 2 qualifications are the same, equivalent? One.
I would put it.
Second query. The rules that we have here in the state says no qualification is prescribed. It says it will be in tune with the qualifications that would be prescribed by NCT from time to time. That you will get it in page 293 of that manual.
Yes.
Now, NCT having not amended it, and the Supreme Court having said that the law laid down by Patna High Court is a bad law, where do we stand today?
No, that is why the first submission was important, because the Supreme Court made a. Let me first address your 2 queries, my lords. There are the NCT regulations at page 129 here of 22nd of September 2017, which my lords are issued because in terms of a section 57 direction. Your Lordship has page 129, my lords.
I got it.
Yeah. So this is of 22nd of September or 2017. What does it say, my lords? If your Lordships will come to page 131, I will, my lords, and no, my lords, I will read from the beginning because this is important. I will read, my lords, 2, 3. The first recital, whereas the matter of recognition, my lords, I'm reading from page
121.
129, your Lordship. read it carefully.
Okay.
Of the 129, whereas the matter of recognition of the project proposal of NIOS program through Swayam portal for training of in-service untrained teachers are considered by NRC, and NRC overserved as follows. Whereas NCT has received directions under Section 29 of the NCT Act from the Ministry of Human Resource Development. We did a letters number so and so. The project proposal for recognition of diploma in elementary education program through ODL mode has been submitted by National Institute of Open Schooling to NCT headquarters. The proposal is for conducting online DEID program through the Swayam portal of the Ministry of HRD for the in-service untrained teachers at elementary level working in government and government-aided private school. So therefore, it is for in-service teachers and it is pursuant to the direction of the MHRD. Then I'll come to the last recital. And whereas in view of the above mentioned directions, of Human Resource Development under Section 29 of the NCT, because under the NCT Act we issue, in exercise of the powers under clause 12 of so-and-so regulation, granted relaxation with a NCT headquarters letter number so-and-so dated 21st of September, letter dated 22nd to the following, 22nd of September to the following provisions in the NCT regulations for ensuring that the directives of the MHRD for implementing the amendment to the RTA Act. What is the amendment to the RTA Act? That they have to be eligible in terms of Section 23. So therefore, it therefore, though it is not stated, but that it is not a question of an equivalence. It is a question of a qualification being acquired under Section 20. Now, my lords, therefore, now, if you be to come big Roman 2, any provision relating to the duration of the program so as to reduce it to 18 months instead of 2 years and the requirement of 6 months internship to be subsumed within the duration of 18 months. Now, Roman 3. Any requirement of minimum eligibility for admission to DED program, that is 50% marks in class 12 to the extent that those who do not fulfill this requirement should be allowed to take provisional admission to a program subject to their acquiring 50% marks for completion of the DED program. Now, Roman 5. Any provision of the number of people who are affected. Any provision prescribing the number and nature of study centers to enable NIOS to cater to around 10 and 11 lakh untrained teachers. So in Assam alone, 11 lakh applied. And there are at least 165 before your lordship. Now your lordship will turn over the page to 131. So now these are the directions. Recognitions. After having considered, whereas was the first recital on this page, and after having considered all the above facts and figures, the NRC considered the case in its 27.5, so decided that recognition to be granted to the National Institute of Open Schooling, Noida, for DEID program to Swayam portal of MHRD for training of in-service untrained teachers. This is a separate category under Section 14 of the NCT Act.
I got it, sir. Any direction you want to highlight here in page 131?
It is a recognition. It is not a direction. It is recognition. Once it is recognized, then it comes within the ambit of Section 23(1). Now, may I take your lordship to the judgment? Because the judgment makes a distinction between fresh recruitment. That is why they said this is only a one-time window of opportunity. It's a 249.
I think there is a further rider by the Supreme Court that this was only for the in-service candidates.
Yes, but there are no. So today, my lord, the petitioners before your lordships are all in service.
If this program 18 months was open to all,
yes,
then it would have been a different ballgame altogether. But it was only limited to the in-service teachers and for the purpose to have them qualified in terms of the RTA Act.
Exactly.
Now, it has also come on note that is 18 months was required because that was the only time left for the last date for compliance of the RTA Act. And these things have been gone into by the Supreme Court.
Please. And the court says, makes the distinction. So therefore, it says it cannot apply to a fresh recruitment, not to untrained teachers. In fact, I will take a lordship to the penultimate paragraphs, but I can also.
Mr. Hazarika, while we are considering the Supreme Court judgment or understanding the Supreme Court judgment, we'll also have to take note of the fact that that case was filed by persons aggrieved by the Uttarakhand High Court following Patna Bench.
Please do not.
That has to be always behind us, in our mind.
True.
It was by the persons who were having that 2-year degree who has come up.
Please
proceed.
So, my lords, at page 257 is where the discussion starts, and where at paragraph 31 is where, my lords, they extract the section 23. Since your lordship has read it, I will not trouble your lordships with that.
We can page 35.
Paragraph 35?
Yes.
Yes, Milad. The government of, Milad, if your lordships don't mind, I wanted to first show you to your lord, because I will come to Uttarakhand
Okay,
separately.
fine. Be comfortable wherever you want.
Because, Milad, if I may say so, I want to show, Milad, how the Supreme Court has very clearly said for in-training teachers and makes a distinction as a class, as a separate class. So Uttarakhand is a separate stand of my submission. If your lordship don't mind, I'll come to that a little later. So basically, paragraph 33, because these are the what your lordships has followed from my lordships, what precisely the Supreme Court has said, paragraph 33. Through the 2017 Act, Amendment Act, a second proviso was added to subsection 2 of section 23 of the RTE Act with retrospective effect from 1st of April 2018. It provides that every teacher appointed or in position as on 31st of March who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years from the date of commencement of the 2017 Act. So this is 34. It can be further seen that in exercise of powers conferred under section 1 of 23 of the RTE Act, central government authorized NCT as an authority, academic authority, to lay down the minimum qualification for a person to be eligible for appointment as teacher. Accordingly, NCT issued notification on 23rd of August 2020 prescribing the minimum qualification. The said notification came to be amended by dated 29th of July. Was an exercise of powers. This is not so relevant. Then I'll take your lordships next to page 30, paragraph 38. Paragraph 38, your lordship has?
You can have just 36 words.
Please. NCT in exercise of powers conferred under section DD, clause DD of 32 of 32, read with section 12 capital A of NCT Act, notified 22 and 2014 regulation, providing for minimum qualification. Insofar as classes 1 to 8 are concerned, the minimum qualification as recognized in the earlier notification remains the same. And which is at 2 years, because they added that 23rd of August notification. Now, there is no dispute on that score. Because what I'm trying to say, that this relates to the general norm, to the statutory general norm. This is today what we have before your lordship is an exception. So that exception
41
is
and 42 is pertaining to that course, the observations of the dealing with that scheme. 41 and 40.
Please. 41 and 40. Your lordships have gone ahead because, in fact, at paragraph 38 and 39, it takes note of those regulations that I pointed out to your lordship.
Right. 43.
43, my lords, if I may come back. All right. In fact, 40.
Okay, you can take me through 42. That will be relevant.
Yes, my lord. That's what I want to do. It is further to be noted that a communication was addressed by the Additional Chief Secretary Education Department, Government of Bihar, seeking clarification regard to the appointment of primary teachers possessing DED ODL qualification from NIS. It will be relevant to the reply of NCT dated 6th of September 2019, which reads thus. I am directed to refer to your letter dated 29th of August 2019 on the subject noted above to say that your representation regarding appointment of primary teachers qualified with DED ODL from NIS has been examined. The primary notifications are those dated 23rd of August 2019, 2010, and 29th of July 2011. Determination of minimum qualifications, etc. The following points are inferred from the above notifications, copies, and I will read as per NCT notification dated 23rd of August and 29th of July. One of the minimum qualification for appointment of teachers for classes 1 to 5 and 6 to 8 is 2-year diploma in elementary education. 2 is relevant, as your lordship is right, correctly observed. As per the NRC NCT order dated 22nd of September 2017, the DED ODL program NIS is only for those untrained in-service teachers and government-aided, private unaided schools appointed on or before 10th of August 2017. The duration of the program is 18 months. Hence, now this is important. Hence, for fresh appointments of teachers to primary and upper primary level, the notification dated 23rd of August and 29th of July 2011 need to be strictly adhered to. That is also a mandatory requirement. Now,
it does not refer to 22/9/2017.
No, for fresh appointments. So today we are not. These are not fresh appointments because these are all in-service teachers who are only changing employment.
We'll understand that. We just take this tentative view out of mind.
Please. So now, it can now, and the paragraph 43 is relevant. It can thus be clearly seen that as on 6 September 2019 is also the view of the NCT the minimum qualification for appointment of teachers for classes 1 to 8 is a 2-year diploma in elementary education. It further clarifies that NCT recognition order dated 22nd of September was only for those untrained in-service teachers in government schools, in unaided schools, who were appointed on or before 10th of August 2017. It further clarifies that for fresh appointment of teachers for primary and upper primary level, NCT notifications dated 23rd August 2010 and 29 July 2011 need to be strictly adhered. Now, this can be therefore any school, it can be government, non-government. It is further to be noted that whereas notifications dated 23rd August 2010 and 29th of July 2011 specifically refer to powers conferred on the section 1 of 23 or 1 of the RTI, NCT recognition order dated 22nd of September refers only to the directive issued by the MHRD under section 29 of the NCT Act. It is it is thus clear that the entire scheme was for the purpose of providing a window to the in-service teachers, inasmuch unless they would have acquired the requisite qualifications prior to 1st of April 2019, they could not have continued to remain in service and would have faced dismissal from service. As such, we find that the High Court has erred in holding that the 18 months diploma conducted by NIS through ODL mode is equivalent to 2 years diploma as provided in the notifications of NCT dated 23rd of August and 29th of July.
So what your contention with regard to that equivalence?
Yes.
Gone. It comes further, it further discusses that.
No, Malak. Today, Malak, I'm on this submission, this strand is slightly different and vastly different. What I'm saying is the court also recognizes, what does it say? It says for in-service and in-training teachers who are already in employment. So it can be employment which is private, government, non-government, whatever. We are giving them this window that by 2019 you will acquire this.
I think that plea that you are trying, let's get off with this equivalence part. 45 and 46, 47 settles that.
Yeah, and 51 also, because what 51 says is that it could have issued. I'm one with your lordship. In fact, when your lordship is on equivalence, your lordship may come to 51. So if may 50 and 51, because again that one-time window is very important. So this is very important because what I'm saying is, Malak, my first submission which I made, that once I have acquired the qualification at paragraph 50 again, as already discussed here and above, NCT recognition order dated 22nd of September 2072 was issued so as to give effect to the directives of MHRD dated 8th of September so as to provide a one-time window to the teachers who are already working and who in terms of the 2017 Amendment Act were required to acquire the minimum qualifications prior to 1st of April 2019. So if they acquired the minimum qualifications prior to 2019, then how can they be non-suited?
Please read the last line also. The said order.
The said order in any case cannot be held to be a direction to the state of Uttarakhand to act in contravention of the 2012 service rules and the advertisement issued on the basis of such service rules. I will come to Uttarakhand. The Uttarakhand rule has a 2-year stipulation which is not there in the MIT. Now, paragraph 51, if your lordships may come. This is where your lordships, because since may I read this? What your lordships have said, is reflected here. We further find that the finding of the High Court that the 18 months DEID diploma ODL course in elementary education conducted by NIOS is equal to 2 years diploma is erroneous. Therefore, there is no notification to that effect issued by NCT in supersession of its notification dated 23rd of August 2010 and 29th of July 2011, wherein it provides a minimum of 2 years diploma as a minimum qualification for appointment of teacher. At the cost of repetition, we clarify that the notifications dated 23rd of August 2010 and 29th of July 2011 were issued in exercise of its powers conferred under section 23(1) of the RTI, whereas recognition order dated 22nd of September was passed in pursuant to the direction issued by the MHRD under section 29 of the NCT Act. So now I'll take your lordship now to last to paragraph 53. And now your lordship may come to paragraph 53, and now your lordship will come to 56.
56.
In view of what has been held by this court here above, we find that the High Court erred in holding that the 18 months diploma conducted by NIS through ODL mode is equivalent to the 2 years regular diploma, particularly so when there was no material placed on record to even remotely hold that such a notification was recommended by the expert body NCT. I have no quarrel with this proposition. I am agreeing with you. On the contrary, the communication dated 6 September 2019, the directives of MHRD are so as the recognition order dated 22nd of September 2017 clearly go on to show that the 18-month diploma was provided as a one-time window to the in-service teachers to acquire the minimum qualification material and the outer limit of 1st of April 2019. In our considered view, the High Court has totally erred in holding that the 2 years diploma is equivalent to 18 months degree. Now, your lordship come to paragraph 57, last sentence. They reiterate that, as already discussed, the last sentence of paragraph 57, as already discussed here and above, recognition order dated 22nd of September only provides a window for in-service teachers to complete their course prior to 1st of April 2019. So now, Malak, your lordship will come back to paragraph 31 where section 23 is enacted. So what does it mean? It means that, now, your lordship will come back to the qualification.
257, yes.
Yes. I'm sorry, I should have gone your lordship. 23. Qualifications for appointment and terms and conditions of service of teachers. Any person possessing such minimum qualifications laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. That's one. Here, NCT Melody is the authority, the regulation, the notifications are there. Subsection 2 Melody. Where a state does not have adequate institution offering courses or training in teacher education, or teachers possessing minimum qualifications laid down under subsection 1 are not available in sufficient number, central government may, if it deems necessary by notification, relax the minimum qualifications required for appointment of teacher. Yeah. Now proviso 2 Melody, which is the proviso in question. Second proviso.
Provided further.
Provided further. Now this is very important, that every teacher appointed on or in the position before 31st of March 2015 who does not possess minimum qualifications laid down under subsection 1 shall acquire such minimum qualification. The Supreme Court finding also that I have acquired a minimum qualification within a period of 4 years from the date of commencement of the Right to Children to Free Compulsory Education Act. This is retrospective. So from 31st of March 2015.
I got it, Mr. Azarik. I got it. What is your submission with the relief you want in this petition?
Today, my submission, the relief today I seek is that the advertisement have to be set aside. Because as far as there are 3 submissions that I have. In terms of the first submission, they are notified that disqualification has to go because it's a complete misreading. I have acquired minimum qualification. This is the Supreme Court finding in paragraph 55 and 56, penultimate paragraphs, and the ultimate paragraph, that I have the qualification, minimum qualification in terms of section 23. So the advertisement has to be stayed on. I have to be directed to participate in the selection process. 1. 2, as far as the equivalence part is concerned, in case your lordships is of the view that equivalence is not there, and the Supreme Court has observed, the way out has also been provided by the Supreme Court in paragraph 51. NCT has issued recognition, has issued regulations. It is their stated stand. So it is now in requirement of their statutory duty under section 23(1) to mandamus can be issued on the basis of the judgment that you issue a circular specifying equivalence, because you have already said this is the minimum qualification. 3, the Assam rule, which is at page 89, Assam rule, which is at page 89, because your lordship does not have the prohibition of Uttarakhand. Assam rules adopts 23rd of August. And more importantly, your lordship will just have, it's at page 89 extract.
I've got it. The RTE rules.
Please, the minimum qualifications for a person to be eligible for appointment as a teacher in elementary schools shall be notified by the National Council of Teacher Education number, so dated 23rd of August, which is the 2-year. Now, the second part is very important. The provisions of all rules, notifications, orders of the government prescribing qualifications for teacher, which are repugnant to the stipulations laid down, not stipulation, laid down by the National Council for Teacher Education, stand superseded. So today, the 22nd of September 2017, which are the recognition order, is an NCT stipulation. So how can the Assam?
Mr. Hazarika, I'm not sure whether you have been brought to your notice. We have another rule specifically for the service wherein the advertisement has been issued.
Yes.
You have a manual, this manual.
Please,
it's called the Assam Elementary Division Provincialization Rules 1977.
Please,
And the provisions of Rule 3. B, C, B, down below. I'll just read it for you. The minimum qualification of a person to be eligible for appointment as a teacher in an elementary school shall be as per notification issued by the state government from time to time in conformity with NCT norms. These qualifications shall be applied to all category of elementary schools. So the rule says NCT, and you are developing an argument that that stipulation with regard to that 18 months is also inbuilt there, and unless you don't exclude that from your rules, you cannot prevent these people from.
And my lord, they have acted upon it, because 2019, 2021, 2023, they have acted upon it. So many of and today, my lord, 100.
We'll hear the AG on that point.
Please.
Yes, Mr. Second.
Yes, Lordship, I fully agree what my learned friend has just said, that 2019-20, we do it. Lordship was a
There
part
is no
of that
estoppel against
litigation.
you.
That litigation is still pending. But now
There is
with
no
the
estoppel
recent
against you.
Supreme Court judgment, Lordship, there is absolutely no ambiguity. It is very clear. Paragraph 51, paragraph 40 onwards, and paragraph 31 and 33. What remains, Lordship? We cannot violate the Supreme Court's order.
Now, Mr. Hazarika wants this court to issue a mandamus to the NCT authorities for incorporation of that in that rules, in that regulations. What do you have to submit on that?
On that, the Supreme Court has also said that till now NCT has not done anything.
So when the Supreme Court has not done
Anything,
should
how can
this
this
court-
honorable
No,
court
no,
rule?
address me on that. Should this court come in?
Absolutely no. This will be clear violation and in conflict of the Supreme Court judgment. Had there been any scope in the Supreme Court judgment, Lordship, that scope would have been there, but there is no doubt or any confusion regarding the language used by the Honorable Supreme Court, especially paragraph 51. Let us start from paragraph 40, Lordship. These are findings. What my learned friend was placing, basically those were arguments.
Mr. Soikia, you can come straight to 45, 46. I think that
45
is,
also, Lordship. 40, 41, 42, 42,
I've seen, I've gone
45.
through it.
Yes, Lordship, I am not repeating. 45.
45.
In the impugned judgment and order, the High Court has relied on the judgment of the High Court of Patna in the case of Sanjay Kumar Yadav and High Court of Tripura in the case of Raju Nama. It is to be noted in the judgment of the High Court of Patna, though a reference has been made to the communications addressed by NCT to the Additional Chief Secretary Bihar, it brushed aside the said communication on the ground that it is nowhere mentioned that the said course cannot be treated at par with the 2 years training course. In the absence of specific order of NCT granting equivalence to the 18 months course with 2 years course, in our view, the High Court has totally erred in finding that since the communication does not mention non-equivalence, it would be deemed to be equivalent.
You
In
took care of
fact, in the earlier 2 rounds,
46 will clear.
46, we find that the High Court of Patna has totally erred in not giving effect to the stand of NCT. As a matter of fact, we fail to understand as to why NCT did not challenge the said order when its specific stand that the said 18 months course was only for in-service candidate and not applicable to phase ones was rejected by the High Court. We also fail to understand as to why communication dated 6 January 2021, NCT decided to accept the said judgment of the High Court of Patna.
47.
47. Insofar as the High Court of Tripura is concerned, it again relies on the judgment of the High Court of Patna in the case of Sanjay Kumar Yadav. We therefore find that the views taken by both the High Courts of Patna and Tripura were not correct in law. What remains, Lordship, thereafter? And paragraph 51.
The submission, Mr. Hazarika, you are making with regard to a mandamus to the NCT, that cannot be issued today. That we'll have to hear the NCT first.
Yes, no, yes,
So
no.
today only we can consider whether we have to permit you
To participate in the
terms of that advertisement and the rule position read in the light of the decision of the Supreme Court. That's all.
No, so my.
To that extent only. The other part can come in once the matter is finally considered after hearing NCT.
I'm in entire agreement. No, but if I may say, and in all respect, because firstly, the rule, what my learned friend was referring to because the Supreme Court at paragraph 53 has said that it did not that the High Court of Uttarakhand erred because there was no challenge to the rule position over there also. So, today my submission would be therefore, as far as
that Mr. Subject to correction is only an approach with regard to one of the contentions raised.
Please.
The Supreme Court gave its verdict in paragraph 46, 47.
Yes.
Because I'm again reiterating, this thing you just cleared to me.
No, but it also,
as I have read, NCT never said these two to be equal. It was for the first time that the Patna High Court said both are equal, do it. The Supreme Court saying that is bad law.
Therefore my submission was because today what is the, because eventually it is the ultimate and the penultimate paragraphs of the Supreme. The Supreme Court says in paragraph 56 and 57 that you have acquired the minimum qualification in terms of section 23. That if I have acquired the minimum qualifications of
Okay,
terms of
okay. Let's test that. Let's
Yes,
test that.
very well.
Let's test that argument. If that was the intention of the Supreme Court, why did it interfere with the judgment of the Uttarakhand High Court and did not pass an order to the NCT to incorporate that?
Because the Supreme Court, my lords, at paragraph 43 made a distinction between, I think paragraph 43, just a minute, 43, made a distinction that it is not for fresh, that for fresh appointment it cannot happen.
This is fresh appointment, Mr. Hazarika. You are not a appointee under the government or in a school appointed in terms of norms of the government. You may be anywhere. You may be a private institution, individual. You may be a contractual work employee with the, or an ad hoc employee with the government. But you don't have a root in the government service.
So may I just, let's look at it the other way around. What is the implication of this judgment? The implication of this judgment that this 18-month course is a valid minimum qualification in terms of section 20.
Yes.
Now, therefore, if I have a valid minimum qualification in terms of section 23, does it mean, what is the implication? The implication that I can not only continue to be employed in my present position, I can also be employed elsewhere.
That's the catch. That's the catch.
It isn't the catch.
That's the catch. If you come to the decision of the Supreme Court, here, it has categorically said,
fresh appointment. Fresh appointment
it will not appoint to fresh appointees.
No, so
No, Mr. Just try to factor in this also in your argument. This 18 months was only to get the teachers across the country who did not have the minimum qualification with regard to RTE achieve that. This was a student-centric approach of the government. It was nothing to do with the teachers. It was a student-centric approach so that the students are not deprived of a proper education from a trained person. Now, keeping that view in the mind, as far as I have understood, the Supreme Court had proceeded.
So
what do you have to say?
So my first submission.
I'm examining this only with the view whether I should permit you to appear in the elections.
I am grateful. As far as permitting me to appear in this whole process, as I said, let me address this query of yours, lordships. Today, if I have that's what falls from your lordship is that this being a student-centric thing may have been the perspective, but in terms of the statute, in terms of section 23, I have the minimum qualification. Having acquired the so fresh appointment would mean, because why it also is, and I think that is because it says that the 6 months internship is subsumed in that 18 months.
Why?
Because I'm an in-service teacher.
No,
Yes.
Mr. Hazarika, you read it further. It was because that time was not there.
No, very well.
Cut-off date to come into operation.
No.
Only 18 months were left. It went ahead.
So regardless of that, today the court has held that I have the minimum qualification. Penultimate paragraph, it says twice, and that was what I wanted to read to you. It says I have the minimum qualification. If I have the minimum qualification section 23 as a teacher in terms of section 23, and I'm eligible to continue as a teacher in my school, why can I not be a teacher? It says fresh appointment. What the Supreme Court meant was a fresh appointment in terms of someone who was not in training. So that is why it said this is a separate class. That is what the paragraph 1. 2 minutes as far as the facts are
I got your point. I got your point.
As far as the facts are concerned, all along the Assam government, the central government, everyone, MHRD, all of them have today 2019, 21, 23, I have been recruited. Now, and Supreme Court in paragraph 51 have also provided the way.
Got it. So you mean to say that the Supreme Court judgment has not considered that effect of 23 proviso.
Yes.
So it's per inquiry. I'll have to declare it per inquiry.
No, it is not. Because the Supreme Court has not said that they are not.
Did not
say that they would.
This direction ratio is binding on me.
No, what it meant in terms of fresh appointment was someone who was not in service. Today in service means someone can be in service in a private school.
No, the advertisement says any person in government service in an LP school cannot apply. You got it. We will examine. Don't worry. We'll examine.
At least permit me to also participate in the process because after all, we are.
I'll examine that because for your information, the government is extending the date till 12th.
Please, my lords.
So till 12th, right?
For is a general. not
Generally, for all,
specific to this.
for all. So these orders, I'll pass it tomorrow morning. Let me consider, I'll pass it tomorrow morning.
But we have serious objections because we do not
Well,
want to.
maybe
do
I
anything in
have
6 months.
understood your objections. Mr.
My objection is for any kind of interim order. Lordship may be pleased to issue notice. We have
Will do.
noted out. Paragraph 15 very clearly takes care of section 23, section 29, and as well as all the notification. And also whatever has Lordship has regarding the 1977 rules.
293.
29. We cannot
Go beyond,
violate that. We cannot violate that.
because I had a doubt first.
Till date,
As Mr. Hazarika is trying to project, has to build up a case, that there was a rule with the Uttarakhand government. That rule was violated and the High Court Supreme Court has made some observation in that line also. I was in doubt as to I did not know that this provision was added. While consulting the book, I got, we are in a better, the state, I think has put itself with NCT.
yes.
Yes.
Or with NCT.
The recognition order is a
And
statutory order.
Lordship, paragraph 53, last line.
Okay.
The High Court, in our view, it is respect of the other cases, the High Court, in our view, could not have issued such a mandamus contrary to such service rules.
Yeah, that is, Mr. Hazarika is also trying to take, but that was one of the limp of the arguments. The
And paragraph
exact-
51 very clearly refers about the
exact-
notifications.
exact nerve of this judgment is paragraph 45, 46 and 47.
Yes, Lord.
Because other than Patna High
And the contemporaneous records in paragraph 51.
we'll try.
Grateful.
Let's see how best we can help you.
And
I am
in 19, 20, 21, we did it because till that time, the Uttarakhand judgment was not there. We are with Hazarika, but today we cannot.
No, my lords, my letter
The Supreme Court
It is
has-
up
That's why my
It is the other side.
opening liner was, I am
But-
supporting him, but today I cannot.
You
say.
cannot.
My learned friend, my lords, only has to construe the judgment as the Advocate General in terms of the manner in which it is given. But in paragraph 56 and 57, that's enough. He says, I'm qualified.
Problem, Mr. Hazarika, I am facing.
The irony is that when my lord Justice Nair was on the other side, we always saw the Patna High Court and Tripura High Court against him.
This was the argument maybe I could have done. Let me consider. Tomorrow morning, 10:30.
I am grateful, my lords.
Highly of the
Ali was the delivery of order. I'll not dispose of the writ petition. I'll only consider the interim prayer and issue a notice. Okay?
We are right.
Minus
Oh,
43 is a connected matter.
Next one also connected. 42 and 43 connected.
Daily list, item 5, top of the list matter.
List before any other bench without me. None to read.
Item 7,
Yes, PWD. PWD. Petitions have retired long back. And the issues that are there are no longer. Anyway, none appears for the parties on call. This dismissed for non-prosecution. Able. Tight up on our bishops. Kumbaile, fully do. Kumbaile, Martin.
yes.
Yes.
Item 8 and 9,
All these cases have been just lying. Last listed in 16, and the other one listed sometime in 14. Same one. দুটা আছে দেই। খালি সাইন করব নিদিব। এইবোৰ তাকে যদি দিন আহে দিনটোৰ ভিতৰত ৰাখি থৈ দিব ডিসপোজ দেখাব নালাগে। দিয়া
Item 10 and 11.
Yes.
Item number 10, my lord, has become infractual.
Hmm.
Because posting, he is already retired, and 11 also, my lord, initially he was terminated, then there was stay order by the time he retired.
So nothing
So
is there.
basically, nothing, sir, but
On the prayer of Mr. A.K. Purkhasan, who submits that in course of time, during in course of time, the issues as arising in the writ petitions, in the writ petition has become infractious. Accordingly, the writ petition stands dismissed as being infractious.
So I appeared for the
Mr. P.D. Goswami appears for
Union
the
Cooperative
Cooperative
Bank Limited. It's a
Cooperative
Fifth and
Bank
Credit Society.
and Mr. S.K. Talukdar represents the corporation department. It's a cooperative bank.
It's a Thrift and Credit Society that
And how come
that
the
bank
writ was
bank
maintainable?
was crept in because of some error committed by the RBI at the relevant time.
No, how
Now
come
the
how
cooperative-
come this court will have jurisdiction in this
My lord.
matter?
yes,
This court will have no jurisdiction in this matter. It's not a state body, it's just a cooperative society.
It's a cooperative. Thrift and Credit Society under the act.
Not maintainable. Not maintainable,
Already-
but nobody took that plea
My lord,
for all these years.
my lord.
You have not even filed your counter.
My- The petitioner is also, my lord, different person, my lord.
Anyway,
He is one man, my lord, who is fighting all the cases over the years.
see, but
He's just one man,
But
my
the
lord.
projections that he made in the writ petition does not show a very good picture of your bank.
My lord, the pictures are all here, my lord, I can place. He is now absconding with 10.5 lakhs, my lord. Much of that.
even then, my lord, since petition doesn't survive, my lord, or she will not make any observation.
We are not making any observation.
My lord.
This is between me and Mr. Guswami.
My lord, this is off the record, my lord, but I have it.
I got it. There.
My lord, ma'am, please, my lord, item 7, my lord, can it be for finding?
Okay. 7 to dismiss for default of criteria, time being good. Yeah.
Thank you.
Come before the second half.
Okay.
Item 12.
May I please, your lordship?
Your lordship, in this matter, PNRD would be appearing, the name of PNRD, standing council PNRD is not reflected.
Okay, fine, no problem.
Most probably because because of that, they have not appeared.
Yes, Mr. Pramia, what do you have to say?
Petitioner appointed as Panchayat secretary
Hmm.
in terms of direction of the government in the year 1992, government
Only thing
created
is that
Panchayat secretary
Hmm.
post. According to terms of meeting dated 15/10/1993, the petition, the resolve to appoint Panchayat.
what do you
secretary
say about the
my-
page 27?
If you not, lordship.
Page 27.
Yes, lordship, page 27. Panchayat Act came into force, lordship, subsequently, that is with effect from
See, you were in a particular Panchayat society. Panchayat, Gaon Panchayat.
Panchayat
Secretary.
secretary, lordship.
That post was not there, gone.
Here is the case, something different, lordship. Prior to the initially government.
You are not in service from 2000.
I am not, but here the directions of this report earlier, lordship, prior to that.
Hmm.
Lordship,
Only the court direction is for consideration of your
regularization.
representation.
Thus, lordship, impute order is at page
27.
27.
Hmm.
Lordship, try to look into the lordship's letter, the page 25.
Hmm.
That letter dated 30th of May 2012.
Hmm.
Regarding WPC lordship issued by the Commissioner of Panchayat lordships to the Chief Executive Officer Jilla Parishad, referring the WBC number so and so.
Hmm.
With reference to the above, I am direct to enclose here the copy of the final order dated so and so passed in WBC so and so in the matter of Sri Horendranath Singh for perusal and necessary action. Further, you are request to furnish the following queries to this commission at the earliest.
Hmm.
Whether the salary has been paid to the petition with effect from.
That you find it,
Lordship, that next
page
page,
26.
Lordship, that next page is important, Lordships.
Hmm.
Page 26,
Hmm.
4/8/2012. May I read the contents of the letter, Lordship?
You can read one. The
Lordship.
salary was paid up to 7,495.
The number,
Right?
Lordship. Then
Hmm.
Gaon Panchayat body, namely Kajigao Gaon Panchayat by so and so and so.
Come to
meeting
three.
held on
3.
12/27/10/90, appointed Sri Horendranath Singh as secretary cum accountant of Kajigao Gaon Panchayat on 7/4/1984.
Come to 4.
That the petitioner engaged against the vacancy under non-sanction clause.
4.
Whole Lordship. That the petitioner's name along with relevant papers were sent by this office letter number so and so dated 10/9/2003 enclosed annexes C. As per record, it reveals that the petitioner was engaged by the Gaon Panchayat body, but the secretary of the erstwhile Mahakuma Parishad Dhubri had appointed another secretary, namely Sri Prosenjit Chen to the Kajigao Gaon Panchayat. Copy appointment so and so is enclosed. The person as to the name of the petitioner not recommended for regulation by detailed secretary Mahakuma Parishad.
So where is
Yes,
Prosenjit
yes.
Sen in this proceedings?
Lordship.
Where is Prosenjit Sen in this proceedings?
Prosenjit.
He's not a party.
I have not challenged his
Well,
appointment.
Because your post, somebody else has taken. That is your allegation. Without challenging his, how can I put you back?
Yes, Lordship. But there is the direction. Nobody can be appointed against my post, Lordship.
Hmm?
In the Lordship, prior to that, Lordship, I am placing the earlier direction, Lordship. The
You come to
interim
page
direction,
22,
Lordship, that
the
is
disposal order.
disposal order by interim direction, page 17, Lordship.
21.
Page 21 is the final order, Lordship.
Hmm.
And page prior to that, Lordship,
The
page
interim order
18.
got merged with this. The interim order not to replace you with another ad hoc
That is
appointment.
the case, Lordship. Even earlier, after disposal of this case, Lordship,
Hmm.
that Panchayat was fall under the BTAD area.
I know that.
After the creation,
So you wanted in somewhere else. So how do you get it in beyond
Lordship,
your
there are vacancies
your
also,
Gaon
and
Panchayat?
all the similarly situated have been regularized. 1700 some posts.
Because there would be
They
a
were created
secretary,
at that time, Lordship.
there would be a secretary at Kushinmara, there would be a secretary at Thakurna,
There is
Bari,
at
appropriate time.
at the time of filing, there are vacancies, Lordship.
No, you have not said that. Show me the
In
petition.
the
Show me the
Lordship,
statement.
yes.
Page 7.
Lordship. Paragraph 7, Lordship, page 7.
Page 7, yes. Last paragraph.
Lordships.
Okay. Now come to your
This stage in the
representation.
month of February, the petitioner got information that post of regular secretary was lying vacant against two.
So this was brought to the notice of the authorities, right?
So, yes, BKD, those two panchayats are Kushinara Doradoya GP and Thakuranbari GP, both under Mankacha Ancholik Panchayat block.
So that plea of yours was rejected in second paragraph at page 27.
Lordships actually rejected they are as per section.
Show me the
30
power of the
Panchayat
president.
Lordship
Show me the power of the president of a Gaon Panchayat to appoint anybody.
That section 30 says the director, but here is the appointment prior to that, Lordship. There is a government decision, Lordship, to appoint the
Where?
Lordship in their affidavit, Lordship, kindly see.
Hmm.
Affidavit they have filed against my paragraph
This is an
number 3,
affidavit
Lordship.
by some engineer Dhubri Jila Parishad. It's not an affidavit by the government.
Affidavit filed by the CEO, Lordship.
No, it's by the CEO of
CEO,
Dhubri Jila Parishad. But we have an order here of the Jila Parishad, Chief Executive Officer, Jila Parishad, right?
Lordship.
We have an order from the Commissioner and Secretary. In this affidavit, those points are never touched.
They have, yes, Lordship. In the paragraph specifically stated regarding my appointment, Lordship,
Where?
paragraph, page 4, Lordship, paragraph 3.
Okay.
That
This
may
has
well-
been dealt with that he has no power.
No, Lordship,
Mr.
government
Mr.
directed. Government
Mr.
directed,
Gorvian,
meeting dated,
no,
Lordship.
Gorvian,
Lordship.
even in paragraph 4 at page 26, same thing is there.
Only they held that the petitioner appointed, they were.
And you come to
having no
page 34,
power. That is
para
the
7,
case,
page
yeah.
34, come to page 34.
Page 17, Lordship.
No, 34, para 7.
34.
This was somebody trying to favor you. Para 7, page 34. Page 3, internal page 3 of the affidavit.
Paragraph 7.
This affidavit was filed in 2013, 1912, 2013. Even this, with this statement, you have not taken steps to implement Prosenjit Sen.
I am repeatedly approaching the authority, Lordship, since I approached this court, Lordships. And here is the Lordship, only ground is there.
And come to page 3, para 7, last line,
Paragraph 7, internal page
3.
Lordships.
However,
As
as
furnished,
record furnished by the petition.
he had been continuing service up to auto,
So-
as observed to the letter issued by the then block development officer, the Withdrawal developers, by this letter dated on.
We'll give it a quietus, Mr. I don't think so there is anything.
Lordships. Here
Because if
all
I have
the
to
similarly
interfere,
is
if I have to
appointed
interfere,
by
I'll have to interfere the appointment of Prosenjit Sen. He is not before me. And today I will
And-
not permit you because you had that instruction 2013 itself.
some time may be given, Lordship.
We'll give it a.
Whether there are in Dhubri area, Lordship, two Panchayat,
Your appointment regularization will be with regard to the post you are holding, not with regard to somebody else, where some other post where you have never worked. That was the scheme.
yes,
So you being a panchayat holder of particular
Panchayat.
Panchayat,
Panchayat
Gaon
was
Panchayat,
appointed again.
you cannot go and ask for your appointment from B.
But they stated that against the post where I was appointed.
You have not made him a
because
party.
fall under BTR, they have no power. So
We'll give
any
it a
other-
quietus, Mr.
That was their.
We'll give
version
it a
of the
quietus. Sorry, next time. Heard Mr. Epat, we Learned Council for the petition. None appears for the Panchayat and Rural Development Department. So the petitioner, by way of the present proceedings, by way of instituting the present proceedings, has raised their demands. As said, a speaking order dated 29/5/2013, by which his case for regularization in service as secretary Gaon Panchayat was rejected. Full stop. The petitioner contends that he was appointed by the president, Kajigaon Gaon Panchayat, by an order dated 7/3/1994, and he was serving therein. Full stop. As the case of the petitioner for provincialization of his services was not being considered, the petitioner had instituted WPC number 5369/2000 before this court, and this court, while order dated 22/9/2000, was pleased while issuing notice to hold direct that the services of the petitioner shall not be replaced by any other ad hoc employee. Full stop. This, they said, the petition being W 5369/2000 was taken up for final consideration, and this court, while order dated 21/12/2005, had disposed of the said petition, directing the respondent number 2, that is the Director of Panchayat and Rural Development Assam, to consider the grievances of the petitioner and pass orders with regard to his claim for regularization in accordance with rules, norms as may be in force. Also, the petition, it was also directed by this court that the further claim of the petitioner that he has not been paid his salaries from April 1995 shall be verified by the respondent authorities, and if any amount is found due, or the services rendered by the petitioner, the same shall be released to the petitioner. Also, the petitioner thereafter submitted a representation dated 1/3/2011 before the Director of Panchayat and Rural Development Assam Guwahati, wherein he, by identifying two vacant posts lying in two other town panchayats outside BTAD area, had prayed that his services for regularization be considered against the post of secretary lying in either of the said two town panchayats. Also, it is to be noted here that the town panchayat wherein the petitioner was initially working, that is Kajigaon Gaon Panchayat, was included in the BTAD area, and accordingly, the petitioner was not able to serve against the said post. Also, the said representation of the petitioner was considered by the authorities, and on being so required, the Chief Executive Officer Jila Parishad Dhubri, via his communication dated 4/8/2012, submitted a report before the Commission, Direct Panchayat and Rural Development Department, Assam, and therein had noted that the petitioner's salaries from 7/3/94 till 7/4/95 was duly paid. And the secretary of the erstwhile Mahkuma Parishad had appointed one Prosenjit Sen as the secretary of Kajigaon Gaon Panchayat. Also, it has also been brought on record that the petitioner was continuing in his services till 36/2000. Also, basing on the said materials available on record, the Commissioner, Panchayat and Rural Development Assam, by his order dated 29/5/2013, proceeded to consider the case of the petitioner in terms of the directions passed by this court, and on such consideration, rejected the case of the petitioner for regularization. Further, further it was provided that the CEO Dhubri shall verify the records and ensure that the wages of the salary of the petitioner for the period of the service he has rendered in the Panchayat is paid to him from Panchayat fund as he was appointed by the Gaon Panchayat. Also, the CEO or the Commissioner, Panchayat and Rural Development Assam, for the purpose of rejecting the claim of the petitioner, has brought on record the fact that the petitioner, being engaged as secretary by the president of the Kajigaon Panchayat by the order dated 7/3/1994, the said engagement was not in terms of the provisions holding the field at that relevant point of time, and the president of the said Gaon Panchayat did not have any such power. Also, by referring to the provisions of Section 30(4) of the Assam Panchayat Act 1994, it was concluded that the Gaon Panchayats could not make any appointment or engagement of any person against any post in the Gaon Panchayat. Also, it was also opined in the said order that the petitioner, having been appointed by a person not competent to do so, his name was not recommended by the secretary, so-and-so, Mahkuma Parishad Dhubri, to the government for regularization of his services. Also, the petitioner has not brought on record any material to counter other than the appointment order dated 7/3/1990. There is no material available on record to show that the petitioner had continued in his services all along till the filing of the present petition. Also, however, the materials available on record demonstrate that the petitioner's services beyond 36, petitioner had not continued in his services beyond 36/2000. Also, given the scheme for regularization of the services of secretaries of Gaon Panchayats, is found that such posts are sanctioned to the respective Gaon Panchayats, and the secretaries working against a non-sanctioned post therein are so regularized. Also, the petitioner's post of secretary, even if it is held that the petitioner was duly appointed no longer continued to exist and the petitioner was not attached thereto after the said town panchayat fell within the jurisdiction of the PTAD, between the jurisdiction of the PTAD, full stop. The claim of the petition for provincialization cannot further be considered as it is his own projected case that against his post one Prosenjit Sen was appointed long back and was working as the town panchayat secretary of Kajigam Panchayat. Full stop. In that view, and so and so, and the petitioner not having assayed the such engagement of said Prosenjit going by making him a party respondent in the present proceedings, although this case was pending since 2013 and 2013, this court is not in a position at this stage, at this late, is not in a position after such large lapse of time to interfere with the appointment made in case of said Prosenjit Sen. Also, in the said view of the matter, the claim of the petitioner for regularization of his services as town panchayat secretary cannot be entertained at this distant point of time. In that view of the matter, the writ petition stands dismissed. However, there will be no order as to cost. The dismissal of the writ petition shall not be a bar for the petitioner to be paid his salaries beyond 7/4/1995 till 36/2000. That is the date on which he was stated to have been working, and for which an order already has been issued by the Commissioner, Panchayat and Rural Development Assam, wide the order dated, for which a direction has already been issued by the Commissioner and Panchayat Rural Development Assam, wide the order dated 29/5/2013. The petitioner shall submit a representation claiming his such areas of pay by bringing on record claims, by bringing on record the set stance of the authorities in the present proceedings. Also, on receipt of such representation from the petitioner, the Commissioner, Panchayat and Rural Development, no? Same.
Yes, sir.
Panchayat and Rural Development shall consider the same and release to the petitioners his due area salaries within a period of 1 month thereon.
Obliged.
That much I can do for you.
Item 14.
May I please your lordship? Lordship, in this matter, I am on behalf of Ms. M. Bhattacharjee. Your lordship, we no longer represent the petitioners, your lordship.
Then you take your seats.
Well, lordship may kindly come to, for the period of the order dated 19/3.
What is the stat
18, madam. It has concluded, madam, against him.
against him?
Yes.
None appears for the petitioner on court. This writ petition accordingly stands dismissed for non-prosecution.
All right.
If there is something, ask him to come back, but there is nothing. The proceedings were pending. His promotion were not granted for that. Now that he says that the proceedings have concluded against him.
Your lordship will keep this order, madam, in file.
No.
It was taken from, the file was taken from us around 10 years back, your lordship.
All right.
Item 15.
My lord, I'm sorry, my lord, in this case, though my name has been shown, my lord, I have filed.
Where is the petitioner? Has she been appointed somewhere else?
My lord, today, my lord, my brief is also not
No,
available. Otherwise, my lord.
It was a review medical board.
Yes,
dismissed.
review medical board.
Dismissed and
13, my lord.
after now, at that point of time, she
Whether
was around
it
25,
survive or not, my lord, it is
36.
space recruitment in 2011. It is a review medical board up to 2013. I have seen the record, my lord, today itself, but
Same order. Dismissed article. Non-prosecution. no? If they come back, we will.
my lord, my lord.
Item 16.
My pleasure, Lordship, my lord. In this case, my lord, some development took place. The petitioner, my lord, expired. But my lord, we have done the, my lord, resignation.
I'm
which was
sorry,
submitted-
Mr. Purkhaista,
My lord.
we can't permit you to bring on records because that permission was granted to you in 2019,
My lord.
October. You have not taken steps.
My lord, only problem was that, my lord, I could not contact anyone.
Then fine, forget it. We are closing it. We will not keep this matter pending. If they are not interested, 2019, you have not taken steps. We will not.
Then some liberty.
It is already abated. I'll
No.
not go into abatement, but it has already
My
abated.
lord,
If I
some
follow order 22,
liberty may be given, my lord, to.
we
my lord.
will not give any liberty. Because from the man died prior to 2019.
My lord.
This matter is pending from
My
2013
lord.
with regard to the fact whether his resignation was accepted or not. That's all.
My lord, lordship kindly appreciate, my lord. My lord, initially, my lord, I made a contact. And at the same time, my lord, I have been told that mother is also, my lord, lying on back. So
Heard
at that point of time, my lord, I was unable to.
Mr. Learned Counsel for the petitioner. And also heard Ms. M. Kemprai, Learned Standing Counsel appearing for the KAAC. Also, it is seen from the order sheet that on 24/10/2019, Mr. Purkhaista had informed this court that the petitioner had expired during the pendency of the proceedings. Also, thereafter, the family of the petitioner has not taken any steps for having the legal heirs substituted in the present proceedings. Also, which demonstrates that they are no longer interested to proceed with the matter. Accordingly, there being none to press the issues arising in the present proceedings after the death of the petitioner, the petition stands dismissed for non-prosecution.
Lordship
I
kindly
have
record my
dismissed it for non-prosecution.
No, yes, my lord, lordship kindly record my submission that I made a prayer for grant me to some liberty. And that prayer
That
is rejected.
19, that's why I have said 19. And Mr. Purkhaista, if some family members come back, file an application, we will open it. No problem.
No, I have made a contact, my lord. They are willing to come.
When at 19, they have not come. That's why I have not gone on merits. I have only dismissed
Right,
it
my
for
lord.
default.
Therefore, my lord, lordship kindly make an observation that.
No. That you come back, you bring it to me. And it's already recorded. You show this video recording. That will be enough. It's online these days.
If I make an application tomorrow, then,
Bring it to me.
my lord. Oh, bless you.
Only not one application. You will have to make an application,
My yes.
delay,
Yes,
explanation,
everything.
everything. Bring it tomorrow. I'm permitting you now only. You give a mention number. But there should not be a plea that the family of the petitioner did not know that this writ petition was pending here.
Oh, only my lord, son is minor.
That plea should not be there.
My lord, son is minor. And mother is, my lord, around
Fine, fine.
about 75 years.
Fine.
But she is a, my lord, old lady, my lord, doesn't have any knowledge.
19 onwards, we can't wait like this.
I will make an application, my lord.
Please do so.
Item 17.
Seriously. Who is appearing for the central government? Can somebody get hold of Mr. R.K.D. Chaudhary? It's a pension matter. Maybe the petitioner may have a roundabout. If nobody appears, we'll appoint somebody as an amicus curiae. Yes.
Item 18.
Yes, Mr.
Yes.
Yes.
Yeah, please, Your
Madam.
Lordship. The case of the petitioner here is that he applied for the grade 4 post in the Health and Welfare Department in the year 2005. And the interview was held in the month of June of 2005. And after that, the results were declared in the month of February of 2006. And even after that, the petitioner got elected in that interview, which is annexure number 4 under page 26.
There is a direction. Yes, ma'am. Proceed. Paresh Hazarika. Serial number 32.
Serial number 32. Lordship.
Okay.
Even after his selection, selection was reserved, and after that he made
You can come to the orders of this court, page 34.
Page number.
34. The last paragraph. Mr. Mehdi, Mr. Chaudhary is here.
He is out of station.
You be here for 2 minutes. You be here. After this matter, we'll call it up. Be here. Yes,
Should I?
please proceed.
Yeah.
That being the
That
position.
being the position, the present petition is disposed of allowing the petitioner to file a representation before the Director of Social Welfare Department ventilating his grievance, and if such representation is filed by the same, shall be disposed of by the Director in accordance with law and by passing a speaking order. The Director shall also ascertain whether the said select list is said valid and the persons selected by the aforesaid notification dated 27/2/2006 have been appointed recently. The petitioner, along with the representation, shall also produce a copy of the order passed today. The said representation shall be disposed of within a period of 1 month from the date of filing. And
Page 35 is the minutes.
yes, Lord,
Right.
he was rejected on the ground that the validity of the selection list
And your case
has
is
expired.
that
on 30.
one Y Ali,
Yusuf Ali.
Yusuf Ali, I think
Yusuf
there is-
Ali and
was appointed.
11, wherein he was his appointment was being made after the expiry of the selection list.
and the respondents have sidestepped that issue and have said that the speaking order in case of Y Ali was passed sometime in 2011.
Yes,
But
Lord.
your case is that he was appointed in 2012,
Yes,
right?
yes.
Yes, Mr. Bora, what is this?
Yeah.
Our order is very clear. Select list is still valid or somebody has appointed recently.
Your Lordship, if I have to go by the affidavit in opposition,
Affidavit in opposition is neither here nor there.
Your Lordship,
You come to page 2, para 6.
page 2, para
6,
7, Your Lordship.
6, last line.
In my affidavit, Your Lordship,
By respondent number 2.
in my affidavit, it's para number 7. Somehow there is some kind of this.
Okay, fine.
Fine.
Proceed.
That with regards to statement made in paragraph 5 of the writ petition, the deponent begs to state that the fact that the validity of the select list was extended for several times, the Social Welfare Department received various complaints on the select list of 2005 and therefore constituted a committee under the chairmanship of Director of Social Welfare Assam to scrutinize the matter and streamline the select list strictly on the basis of merit. The committee has streamlined the select list on the month of February 2011. The minutes of the meeting held on 15 February 2011 speaks that the committee decided to request concerned department to submit details about filling up of backlog vacancies within 28 February 2011. The department was given time up to 31/7/2011 to fill up the vacancy as per the new list. The Commissioner and Secretary issued an order on 7/7/2013 stating that validity of the list will 2011, it should be 11, I believe. The validity of the list will expire on 31/7/2011. The minutes were annexes annexure 1 and 2, Your Lordship. Also later on, if I may take Your Lordship to paragraph number 11, page 4 of the affidavit. With regards to the appointment of Yusuf Ali. Now, with regards to statements made in paragraph number 9 and 10 of the writ petition, the deponent begs to say that the fact of the matter is that the respondent number 3, Director, Social Welfare Department, Assam, had taken the hearing of the writ petition on 21/12/2012, whereas the validity of select list was expired on 31/7/2011. It would be pertinent to mention herein that the case of Yusuf Ali, the Commissioner and Secretary, Social Welfare, passed an order on 7/7/2011, that is before the expiry of the validity of the select list
I got it.
issue.
But the order of this court is if validity plus if somebody was, you tell me one thing, just clarify one thing. There is a list which is having a particular validity. All appointments have to be made within that validity. Can it be made beyond?
Your Lordship, it was extended from time to time.
Okay, till 11 we said.
Otherwise,
31/7/2011, the cutoff date. Can any appointment be made after that date?
Your Lordship, till the validity of the select list, Your Lordship, appointments can be made. But
Fine.
after that, Your Lordship, the
So
validity has to be
mind your
extended.
words, you're saying appointments can be made. Decision for appointment to appoint and appointments are different things.
Different.
So in paragraph 11, what is being said is the decision to appoint. It's not the appointment.
In my affidavit, your lordship,
That which you last read now,
that as regards to statements made in paragraph number
9 and 10. The last line, it would be pertinent to mention here in that in case of Yusuf Ali, the Commissioner and Secretary so-and-so passed an order on 7/7/2011. That is before the expiry of the validity period of the select list is issued by the Health Department. Now just get me the instructions, receive instructions, when this appointment took place. Anything on record to show when Yusuf Ali was actually appointed.
We only have this appointment letter, lordship.
You have a letter, give me.
This is annexure number 11, lordship.
Okay, now come to annexure number 11. Yes, this is what I'm saying.
Dated 1/12 of 2012.
So 1/12/2012, right? How did you appoint? If your validity is of 31/7/2011. Appoint the petition. We should not take matters of persons with disability like this. No, will not.
I'm sorry, your lordship.
You have your instructions.
Lordship, may kindly give me 1 day. Your
One day, don't problem.
lordship.
We'll have it on Monday.
Monday, your lordship.
Mr. D. Bora shall receive instructions as to why. One, why Yusuf Ali was appointed in his services after the purported expiry of the select list on 31/7/2011. It is the projected case of the respondents in their affidavit that the Commissioner and Secretary to the Government of Assam Social Welfare Department had provided an order dated 7/7/2011.
Appointment is a health department.
But provided an order dated 7/7/2011. Directed for the appointment of said Yusuf Ali, but it is seen from the records that the approval for such appointment was given by the Health and Family Welfare Department only on 1/12/2012. The respondent authorities to explain as to why the appointment of Yusuf Ali was effected after the date of expiry of the select list, and the same benefit was not given to the petitioner in spite of directions passed by this court while order dated 2/8/2012 in WPC number 3652 of 2012. List this matter again on 7/2. We'll give you one more day, 7/2. Let us see, ma'am. If it is within that 31/7, everything has finished, you have no case. If there is something, we will see. Right? 7/2, huh? Right.
Timing item 17.
Wait, please, sir.
What did you do? Ma'am?
I'm sorry, your lordship, it matters.
No, it's okay. Only
In
thing,
this case, lordship, intervention would be required, lordship, because.
that's what I'm saying. That's what I'm saying.
Because the case of the petition.
Because see, the manner in which you have dealt with that lady's case is
I understand,
not proper.
Being fair, lordship, done.
The stand that she had taken that she had none, but she was totally dependent on her son, was totally ignored.
100%, lordship.
And what is 1 lakh these days in a year?
Lordship?
Anything? 1 lakh in a year is something for survival.
No. Today's. These days, lordship, it has no very less value.
Mr. Bora, D. Bora, you're not a central government standing counsel. Come. None appears for the petitioner on top. Considering the issue involved in the present proceedings, Mr. D. Bora, learned counsel, was requested to act as an amicus in the matter. Mr. Bora has readily agreed to act to assist this court in the matter, and accordingly, D. Bora is appointed as an amicus curiae in the matter. Also heard Mr. C.K.S. Sharma, C.K.S. Borwa for the respondent authorities. The raised shall Very good. The registry is directed to furnish to Mr. D. Bora, advocate, a copy of the petition along with the affidavits and its enclosures within a period of 7 days from today. Also, list this matter again on 13/2/2024 for further consideration. Mr. Bora, it's only a question the mother. Man died without being married. So the parents get it. They have rejected the case on the count that the dependency is not there with the son. That is the law, 5410A of the 6 years rules, that's the law. But she had brought on record certain stance that I'm leaving alone. My husband, my elder son have abandoned me. These aspects were never considered. It just went by the fact that the husband is employed somewhere. He gets an annual salary of 1 lakh. So, not. Please, assist, go through it.
Yes.
And Mr. Burwa also, you also look into it.
Definitely, I will.
We may not be able to move much into it, but at least if we can direct for a re-examination of the matter.
Item
The
19,
registry to reflect the name of Mr. D. Bora as the amicus curiae in the matter and Mr. C.K. Burwa as the learned counsel, learned CGC appearing in the matter.
Hold on. Obligation. Awesome.
Double jeopardy.
Double jeopardy.
23.
Only thing, my lord, disciplinary proceeding, penalty imposed. My lord, I am not against that.
Criminal case charge sheet file.
Charge sheet filed, evidence stage.
See,
My lord, 2 parallel proceedings and my lord.
this is not a parallel proceeding. You satisfy me, this is a parallel proceeding. Because it's provided for under our acts.
My lord, I take your lordship to the General Causes Act, section 26.
Huh?
General Causes Act, section 26.
You take me to educate me on that. General Clauses Act.
If 2 different provisions, 2 different enactments are there.
This is not a Mr. Roy Chaudhary, this is not a proceeding.
My
This
lord,
is just an inquiry.
my lord, I place before
And
lordship.
see, every government employee is duty bound to place on record this.
My lord, I am duty.
You
bound.
show me that you are not required to place. I'll interfere.
My lord, only thing that I want to place before your lordship is this. Because here, if I place all these assets and liabilities.
You
30
are to.
My
You
lord,
are to.
there
It
I
is
will be
deemed to be
prejudiced.
there.
There, I will be definitely prejudiced before in the criminal trial. My lord.
Wait, it's too lopsided.
My lord, here,
Liability and asset is too
my lord,
not balanced.
my assets and liabilities has to be disclosed over there.
You have to, where is that provision, Mr.? It's there, services manual. Wait, I know.
It's in the rule 11, your lordship.
Rule 11 of the conduct rules, na?
Lordship.
Right. Services manual conduct.
Only, my lord, before your lordship goes to that, my lord, if your
Okay.
lordship look into page 45
40
in the petition.
of that manual.
No, the petition.
I'll just go through it. Yes, it was, which provision, Mr.
Lordship, rule 11.
Conduct rules? Mhm. Yes, come to rule 11. Are you also prevented by, will it, this also be hit by 23, article 23?
My lord, here your lordship finds. My lord, though I have not gone through these provisions. My
Go
lord,
through. We'll have it after some time. You go through. You go through. That is
my
the
lord,
case.
then your lordship fix it on.
No, today. Today. Last time also we accommodated you.
No, my lord,
Today. It's only this question. You take me out of this. I
My lord,
will follow your.
my submission before your lordship is this. Here.
What is that you wanted to show me? General Clauses Act 38,
Section 26.
section
26.
stay. This is not a penalty. No penalty can be imposed upon you. They will have to draw up a separate proceeding for that.
That is what, my lord. Prosecution means initiation of a proceeding. Prosecution means initiation of a proceeding.
That's why you have brought on record the judgments,
My lord. The judge-
wherein the Supreme Court has said
that
prosecution will also mean an initiation of a judgment.
proceeding.
Okay, fine. Now, let us factor in Rule 11 also.
My lord. Oh,
If
honest-
Rule 11 mandates that every government servant has to annually give this return,
my lord.
then
But here in page 45, what they have said, that is said that the above information is required in connection with vigilance inquiry initiated.
because it is not there, it ought to have been there on records. It is not there on records because you have not furnished it. You have violated 11. You are in service or retired?
I am in service.
You are in service.
I am in service.
I don't know why they have not proceeded against you.
No, they have
Departmental.
proceeded, penalty was imposed
No, that is on the merits, on the allegation. On this count,
because there is a stay order.
because any violation of the conduct rules is a misconduct.
Misconduct. That is also there. Well, that is why, because for
You satisfy me on that.
11, my lord, can it be, my lord, only for a day, my lord? Monday on 11, I will submit. My lord. I have gone through that way because General Process Act Section 26. Because this is the proceeding what I find it.
Mr. Hazarika, anything more than that you have to submit or 11?
No, this is the thing, your lordship, that
And also an explanation why you are not following Rule 11
Rule.
from the
Well,
date.
On Rule 11, I will submit your lordship on Monday. Let it give it part out, my lord.
No. Let's this matter again on. Today is
Thursday, my
First.
lord. Let it be on Monday.
5/2/2024 for further consideration.
Time being 7.
Maybe you're, better relation, non-promotion of the petitioners, my lord.
Hmm.
As sub-engineer, my lord. Great, my lord. My lord, that-
Mr. Soikia, not much time. Huh?
my lord,
Just one query
yes,
can just satisfy me. I'll proceed with you now. Come to your prayer. Your prayer,
Oh,
page 10. Right?
yes, my lord.
Here you have challenged the promotion of the private respondents as sub-engineer grade 2, right?
Yes. 5 to 30,
Okay. Okay. And then to promote you people.
yes.
But the thing here is, you say, referring to that 2026 page 16 gradation list, that there is one for both the directorate and the state, right? One list. The respondents have come by way of an affidavit. Categorical statement that list, we have taken a policy decision. It will be directorate and district separate. Where is that challenge to that policy?
No, my lord, first thing is that there is so specific rules.
Forget it. That's why I said, if there is no rule, their decision, that will be the rule. That will be the procedure.
Initially,
Executive order.
the gradation list, my lord. The from gradation list, it contained the name of all employees.
I know that.
Even the person who are working under executive engineer and those person who are working in the.
And she has retired by this time. The
They
lady.
retired, all the things, they retired, my lord.
So tell me. And you have not even in your reply
No, we have,
assailed. Only a vague statement that such differentiation is in respect of technical posts, non-technical
ministerial service,
ministerial service posts. It will not apply. Beyond that, there is nothing.
because.
How can I now, in view of that policy decision of the government, interfere it without a challenge?
My lord,
Correct me if I'm wrong.
no, my lord, the first thing is that, my lord, initially they made the gradation list for all employees, my lord, for employees. And but after that, what they did, my lord, they promoted the private respondents only. They promoted the private respondents.
When was the promotion? It was in
My lord,
sometime in
on
2011.
4/7/2011.
And this decision is of 2008. You come to internal page 2 of the affidavit filed by SM Bakir.
No, my lord, this order, my lord, page annexure 3, my lord, kindly see.
Hmm?
Annexure 3,
Page
page 30 of my writ petition. This was in 2012 only.
No, the promotion order was of 2012. No doubt about it.
Promotion order was of 2011.
Huh?
Promotion order of
11. You come to the affidavit. Or come to page 7 there. This is a decision of 10/7/2008. After this, without a challenge, how can I proceed? Just show me how can I proceed. And then that list was issued in 2010. You got it. There is no abatement on record to show that you had objected to that. Unfortunate. Give it a quietus. Can't help it. Only on that point.
My lord, if your lordship permits me only one day, my lord. On
This is not a case. I'll give you time till 2 o'clock. Go and read. Come back at 2000. Anything more, Mr. Katonia?
No, my lord.
Hope you have not reversed that decision after that. After the persons have retired, you have not reversed that decision. It's still continuing.
In fact,
Directorate.
yes, my lord. In fact, I'm appealing for the private respondent here, my lord,
Okay.
not for the department.
Okay. Toko.
Yes. Supplementary list, item 37, top of the list matter.
Yes, Mr.
My lord.
Yes.
Your lordship directed me, my lord, to submit a cert, my lord.
That will be better. Yes, anything. Okay, fine. The parties, in terms of the directions passed by this court, have today submitted their respective written arguments in the matter. Full stop. You have given me that
relevant portion of the regulation.
regulation,
Yes,
along with the relevant regulation, relevant pages of the regulation holding the fee. The said arguments are taken on record. List this matter again on 8/2/2024 for delivery of orders.
Lord, I am only relying on the two constitutional bench judgment, one of 1958 and one on 61, on reasonable opportunity and cross-examination.
Okay, that's that aspect.
Much.
It. Jackie. Oh, 41 tours.
Item 38,
Yes, madam. You have the records?
Yes, we have.
Mother, before lordship would edit the records, may I please submission of lordship permits, madam? I've gone for the brief again.
What difference would it make me in seeing,
In my attempt.
my
to persuade
prejudice
the-
me in seeing
It's
that?
okay. Lordship may go through the records. Even after going through records, I may submission.
You want me prejudiced before I,
No, before, after that, even I can make
okay,
a submission.
proceed with
after.
your arguments.
My lord, here is a case. I'm not on the complaint anymore. Whether the complainant was there, was not there, I'm not on that. There are 3 articles of charges against me. The first article of charge.
We have already said, first article for this court, as far as this court is concerned, inconsequential. 2 and 3.
So far as the second article of charge is concerned, the second article of charge refers to unerringly and invariably a particular document which is called a mark sheet.
Look, hey, madam, you just give me that record.
I'll refer to that.
I got it. This is what you literally argued on that.
No, I'm developing on a point. If lordship
We'll
permits,
see, we'll see, we'll see, we'll see. Let us see the fact first, then the interpretation. Madam, where are the exhibits in the inquiry? Exhibits coming on record in the inquiry? Statements of the witnesses?
Statement of witnesses are not there.
Not there. What records have you brought? Huh? Department proceeding records means that record, inquiry officer's record. Just wastage of time.
Even without the records, if I may address on.
No need. Once we have said we want the records, we want it.
Very well, Milord, but
Have the records by tomorrow morning.
but may I address a particular point which may, it may help them also, Milord. A particular document is sought to be held against me with the allegation of tampering, and A, B, C, D, E findings are recorded. Without that document on being requested being given to me,
You
Or
show me where you have
absolutely,
requested and
page 65.
where did you? Very good, very good.
It is
The
deliberately held
university
against me.
authorities were required to produce before this court the records pertaining to the inquiry held against the petitioner. However, the said records have not been placed, and the records that have been placed does not contain, as stated by the learned counsel appearing, does not contain the statements and the exhibits coming on record in the said inquiry. Yes.
Page 66, second paragraph. In respect to article of charge 2. May I read? In my defense, I say that I've never ever tampered any document. I deny that I have tampered official examination marks on IPP 502. I deny that there has been hostile environment by any act of mine. I state that no document reflecting such tampering of official examination marks on IPP 502 papers by me has been indicated in the list of documents annexed herefor and has also not been furnished to me, and as such, I cannot dwell in defense on such a baseless allegation further. I am on that, sir. They have held the document against me. The inquiry officer erred in law, as also in facts below. I was never allowed the chance to face that document.
You come to page 77.
My lordship.
This was pre-inquiry.
This was
You did not
on the
get it.
same date, 13/2.
No. No, there you see.
66 is
A.
pre-inquiry.
A. That is
Yes.
pre. This is after the inquiry,
Yes.
wherein
Whitener.
that materials were come on record in the inquiry. Right. We'll presume,
Absolutely.
subject to that.
But
We
it was
presume
not in the
that
list of
material had come on
documents.
record.
List of documents, and I took a stand
Fine,
in my WS.
fine, mister. We'll have to see what prejudice was caused to you.
Absolutely.
Huh?
Good.
If you have not asked, said,
I
that
asked.
without that document, I will not I am not in a position to counter.
66.
No, that is
Mistake.
pre. That is pre. Post, you see what you have written.
66 is W.
See what you have written in page 77.
13/2.
70 now.
13/2.
Hmm.
However, I decided to later on, yes,
So here
A.
also the same plea.
I stated that after use of whitener, the previous marks naturally becomes illegible, unclear, hazy. In that case, it becomes difficult to say what was the previous marks awarded. Therefore, I stated it might be 45 earlier, which was rated as 55. I asked for the document which make it clear and stated that I'm yet to receive copies of statements by examination by witnesses in opposition. My lord, I pause for a moment.
I asked for the document.
Absolutely.
So your contention here also is the same as there in there, that they had not produced, they have not given you a copy of that mark sheet or the answer script, right? I'm saying in your favor. Why are you having that
No,
look?
I'm thinking aloud.
So that is why I want to satisfy myself.
Correct.
As to in what manner that was produced in the inquiry. That is why the records.
Because usually when we file writ petitions and all, my colleague may have the paginations done and may use the whitener to correct whether it amounts to tampering. That was the case.
But
To
if
confirm,
he is using that whitener 6 times for one page,
perhaps
then maybe
Perhaps.
we'll have some doubt
within the authorities,
whether
of the-
he should be permitted to do the filing.
but that should be put to me as I see it. And I could place the 2023. That is the not the judgment. I'm not in judgment. Sir. This
Okay,
is
we'll see.
the OM.
Madam, when can you get it? Tomorrow morning?
Your lordship, we have asked them for the statements. Actually,
Not the statements. I want a complete file which the inquiry officer had made and sent to you after the inquiry.
We have asked them it will take a little bit of time because they personally come and hand over us the file.
Or should we call them? They'll come early. We can call them. There is no problem. With the file, they'll come and stand here. They'll assist you. List this matter again on 13/2/2024. By which date, if the records as called for is not produced, adverse inference thereon shall be drawn by this court.
Obliged.
We'll proceed with that matter, drawing adverse inference in that, because this is a matter of 2015, 13/2.
Item 39.
My lordship, and this matter kindly adjourn this matter for today, because
Where is that application?
next kin certificate is not received yet.
Huh?
A next kin certificate is
Huh?
not received from
Eh?
the legal heirs.
You said you will bring on record.
So next, the petition
no.
is expired
No.
January. Next kin certificate is not.
Just
received.
13 case. If they are not interested, why should we proceed?
My lordship, my senior instructed me to say this.
Huh?
My senior is instructed me to say this.
Okay, fine. We have heard it. Now we'll pass orders. Tell your senior that we have passed this order.
Kindly pass over.
Give me a reason.
The next kin certificate is not received.
What?
From the legal heirs, next kin certificate.
Next kin certificate.
Yes.
Oh,
For,
why?
from the legal heirs.
Why? Why is that required? Any doubt they are the legal heirs or not?
The petitioner is expired.
Fine. His wife is there. Service records will show. List this matter again on 15/2/2024. Permitting the legal heirs to substitute themselves, legal heirs of the petitioner hearing to substitute themselves in the matter. So in the event no such application is filed within the next date, the case being of 2013, no further adjournment would be granted on that count in the matter.
Okay.
Item 40.
May I please, your lordship?
Yes, what have you got, madam? Page 30. You were fit. Why didn't you join?
There were some lapses, yes, lordship, on the part of the petitioner. but-
This takes away the basis. Your that Ayurvedic treatment goes for a 6 up. Kabiraji. Okay. Anything more, madam, to add?
No, lordship.
Nothing? List this matter again on 15/2/2024 for delivery of orders. We'll consider.
Much obliged.
Daily list for motion item 20 and 21.
May please, your lordship. My lord, item 20 is listed for consideration. Here, my lord, my prayer is very limited. My lord, what has happened?
Mr. Talukdar never makes a prayer which is beyond limitation.
No, my lord, in fact, what I'm saying, it can be disposed of today, my lord.
No.
Because,
I'll have to think about my people also.
no, my lord, in fact, what I'm saying, the order is in my favor, saying that, my lord, I'm entitled to provincialization.
Okay, fine.
So,
And the court has given its reasons
my lord,
why it should not. We'll consider.
yes.
We'll consider. You have your instructions, madam. We'll not give, we'll give a short date. We'll consider.
In both the cases matter, we have filed our advertisement.
That is never going to come on record till 2025.
Today file.
20, file.
My-
My lord can take up 2 pages affidavit, my
No,
lord.
We'll file it. We'll file it. Get it on record.
My lord.
The Ms. S. Sutia, Laret, Standing Counsel, Elementary Education Department submits that the affidavit on behalf of the respondents has been filed today.
Right.
Registry to trace the said affidavit and tag the same along with the records and list the matter again on Notary Kene 9/2/2024 for further consideration.
Maybe taken up after 9, my lord.
After 9.
I have some problem.
12th.
My lord.
13
One.
13 to 20.
For admission, item 22.
But,
You are the second wife
second one.
and you are the first wife. So entitlement not disputed. Disputed. But this court finds there is picture of both the wives together in a happy mood. You are getting the pension.
Yes.
And
Marriage is also disputed, my lord.
Forget it.
Her marriage.
forget it. After this thing, nothing remains. You go before the court in terms of the full bench judgment. If go before the criminal court 125 maintenance in terms of that WA 160 2018.
My lord, here, my lord, page 4 paragraph.
She is duty
9.
bound to para 9 there.
Yes, my lord, I have seen, my lord.
What more is required?
Only, my lord, it is also, my lord, provided department may.
That court has already held. After holding that, it said go there.
But here admitted position, my lord, paragraph 9 in your affidavit, my lord.
The Mr. Barbia, whether you have understood or not, I don't know.
I have understood, my lord,
Then the court said that direction cannot be issued to the state to issue 2 PPOs. If the state on its own wants to issue, we have nothing to say. But otherwise, no direction will be there in terms of 143.3, read with the note. If she is not maintained, she is duty bound. She is that is not for her.
yes, sir.
It is on behalf of all. She is holding it, including you.
Yes, my lord.
So
Dependent.
if she is not giving you that amount, you go and claim that in the manner known. The remedy thereof would be to make a claim for maintenance in appropriate forum under law and not a claim for payment of family pension by the state authorities directly to such person. After this full bench, my hands up. Right? Disposed of?
My lord.
Get the order on Monday. It will dispose of.
Oblige, my lord.
Mr. M. Morgan, running counsel for the petition. Mr. Ayat Sekia, Mr. Sekia, you are appearing for? Ayat Sekia for respondent number? Respondent number 6, Mr. A. Hassan for the respondent is in the AG, Assam. Ms. M.S.D. Das Burman for the Director of Pension and Public Grievances, Mr. A. Fukan for the Standing Council, Elementary for the authorities in the Elementary Education Department.
Oblige.
Note to Mona and Department. Fine. Wait, Mr. Secretary, we'll pass the order. About it, we'll pass it in the chamber, no problem. About it. Quinta order, sit down, it's possible. Yes. Yeah.
Item 24.
23 to give. I know.
My pleasure, lordship.
Your item number 24.
24, lordship.
Okay.
Lordship, the matter is related to compassionate appointment, lordship. Husband of the
I have seen it, Mr.
lordship.
But your case was duly considered not once, but twice, thrice. And thereafter, the board came to the view that as 2 years had lapsed, so you were not given. I even went and saw as to who was given, whether they were better placed than you. The person who has been granted this compassion appointment is one Niru Gugui, whereas your net worth is 7,77,001.
Lordship.
The lady's net worth who has been appointed is 0. Give it a try this. Trouble, but can't help it. We'll proceed with these instructions. Anything more you have to add, Mr. Counsel?
No, lordship.
Feel free to say something if you have. That just I disclose my mind so that if you have anything to counter, counter.
No, Lordship, it's
The petition by way of instituting the present proceedings has raised a grievance with regard to non-consideration of a case for appointment on compassionate grounds pursuant to the death of her husband. Also, the husband of the petitioner, while serving as husband of the petitioner, late Mohendra Kaputi, while serving as an LDA in Amtola, Tombikikal, Tarkati, ADK High School, page 6, had died in harness on 19/12/2015. Thereafter, the petition had applied for appointment on compassionate grounds on 10/6/2016. It is the projection case in the petition that the application of the petitioner was not being considered by the constituted bodies, and accordingly, she and her family is suffering on account of financial penury. In terms of the orders passed by this court, Ms. D. Das Burman had placed before this court the instructions received from the Office of the Deputy Commissioner Lakhimpur, not Lakhimpur. And in terms of the said instruction, which is accompanied by the minutes of the district level committee meetings, reflects that the case of the petition was considered by the district level committee in its meeting held on 24/2/2017, 16/2/2018, and 4/7/2018, and finally, in the meeting held on 4/7/2018, the case of the petition came to be rejected for want of vacancy within the 5%, and also in the meanwhile, said application having remained without and also on the ground of lapse of 2 years from the date of submission of the said application, holding the application to have splendid exposed. I have considered the materials coming on record and find that the case of the petition was duly considered by the respondent authorities, and it was only on account of non-availability of vacancies in grade 4 post, the case of the petitioner could not be recommended for appointment on compassionate grounds. So in the said view of the matter, the authorities having duly considered the case of petitioner, no error has been caused in not appointing the petitioner on compassionate grounds, and accordingly, the petition stands dismissed, and however, there shall be no order as to cause. I don't say. Your name?
B. Borgo, my lord.
B. Borgo.
Must oblige.
Next time, better case.
Item 23.
Yes, Mr. Suma.
May I please, Your Lordship? Lordship, petitioner challenged the influence suspension and dismissal order dated
Mr. Soma, you are appearing for the
Private
college.
respondents.
Yes.
Private respondent.
As well
College,
as,
college who is appearing?
5, 6, and 7, lords. The governing body.
Okay, okay, you are the main man.
Yes, lords. We are the.
Yes. Where is the shukos issued to you?
Lordship, actually, petitioner not received a SOCOS notice. Lordship.
Okay. Then?
The petitioner filed another writ petition, Lordship, to silence the suspension order. During pendency of this case, petitioner got to know that he was dismissed from the service.
Okay.
That's why petitioner.
This is the only
Liberty.
ground on that you did not receive the shukos notice.
Yes.
Enquiry report also not received.
Not received.
Not received. So
And another legal point is that it is there is a prior approval of the director is necessary.
Prior
was
approval
not
of the director
taken
is necessary.
By the GP.
And
This is
okay.
basic down.
Now, one more thing, your services have not been provincialized also.
Not provincial, other qualified based.
Anything more?
No.
Yes.
Lordship. This
Why
so-called
was the show cause not notice not?
so-cause was issued to him through
Where is that?
registered post. Lordship, your lordship will get it in our additional affidavit in opposition filed by the respondent number 5, 6, and 7 on 27/7/2018.
Okay, fine.
Your lordships may kindly this is this search sheet
Page
at
131, running
14.
page 131, page 14.
page 14, lordship. This is the search sheet. Along with the search sheet, lordship, the statement of allegations. As your lordship, there he has not challenged any of the charges, so we can skip without reading the search sheet as well as the allegations. Then, lordship, at page 20,
Refused.
we have annexed
Refused.
refused. Then, lordship, next page 21, this is the letter issued to him whereby he was directed to appear in the inquiry on 27/7/17 at 10 a.m. That was also sent to the registered post. That was
Okay.
also refused
Now
at
come to
page
page
24.
21. Come to page 21.
21.
Why should he appear in that inquiry?
The writing, I have also seen the writing, lordship. And
If it is suspension, it's not a department proceeding.
lordship, this is the, as because the inquiry, departmental inquiry on the basis of the charge.
No, with this is
Yes,
saying
yes, yes, they-
of your
lordship,
suspension.
they are layman, lordship.
No, no,
So
they may
he
be
was,
laymen.
he was suspended because of the allegations, statement of allegations, he was suspended. That is why they have written like this. He is not the inquiry officer, the manager
So
has
suspension-
directed.
Mr. Sharma, suspension precedes or
No, lordship, that
Post
according to us,
26,
lordship, it's wrong.
2007.
Yes, I also admit.
when is the date of your suspension?
Suspension date is lordship 2017 to 2016.
27? 27?
2017, 2016.
27/10/2016. So this is the show cause.
Yes,
It cannot be.
that's it.
If the suspension is of 27/10/2016,
Yes,
16.
yes.
Okay.
Earlier,
Okay, then
lordship,
what happened?
this was also refused by him.
Okay.
Then, lordship, this was refused, which is reflected as page 24.
Hmm.
Thereafter, lordship, the
Inquiry
inquiry,
report not sent.
inquiry held
Not
ex
sent.
parte,
Inquiry report not sent.
inquiry report sent, your lordship will get it in our additional affidavit filed by the respondent number 5, 6, and 7,
Hmm.
filed on 13/11/18.
Hmm.
Those lordship we could not annex because of this lordship. We have annexed it. It was sent through the. This is the acknowledgement book, lordship. Through peon lordship, it was sent at
Okay,
page 5.
why was it not sent earlier? It was sent on by registered post. Why was this not sent by registered post?
It's a dispute of question of facts, lordship, in that
Okay,
case.
then
And lordship, this is the report of the
your person.
yes, lordship, the peon
Okay,
at page 6A, annexure YA.
okay. This
Be
is the
it-
case. Your case is that we have maintained the complete procedure.
Yes, lordship.
And
this
we
is
have
our
come to
case.
this conclusion. Mr. Gugoi, you have no role.
They have.
Just I have pointed out one thing.
Yes.
No rule, but I have to point out the law
Yes, tell me.
regarding. So lordship may kindly, there is these books, lord.
Page.
Probably it's lordship. Page 2, lordship.
Hmm.
Page 2, lordship. Page 2, lordship.
Two.
Page 2, lordship, notification, lordship.
It also extends to this.
Lordship, it should be the tribunal, lordship.
But tell me one thing.
Abdul Ghaffur, lordship.
Oh, okay, fine. Tell me one thing. His services not having been provincial,
Lordship.
his plea that it should be the director's approval is required, is not called for. What, this school was provincial, college was a venture college, it is not under the aided rules
This
also.
is this Bensa college, not a aided college.
Aided college
Not a
also.
Aided college. Aided college, otherwise, lordship, full bench says that it's a disciplinary proceeding, it should go to the,
No.
as per paragraph 47, lordship, it should be by the tribunal, lordship. Only. this
Yes,
one.
concept.
Lordship, As per Assam Panchayat Education Institution, employees to be government servant.
Hmm?
As per Assam Panchayat Education Institution, Provincialization of Services Act 2011.
Hmm.
Section 4, employees to be government servant.
Have you been provincialized?
Underqualified,
Then-
not provincial, right?
then-
But
You otherwise you refuse. What do you say about the refusal? You have not dealt with that
no.
in your
petition-
pleadings.
petitioner resided in about
Forget it. They have made categorical statements that this was sent to you in this mode. You refused.
that type of.
You have
petition,
not-
no knowledge, Lordship.
You have not even counted
Because
that.
in his decision, his father was residing.
Whoever it is. You can't take that plea now. Go
But,
before the tribunal, all disputed
First of all,
question,
we,
prove that you have not got it.
Suspension order because there's suspension order.
Forget suspension. Suspension is gone. Now it's the default proceeding.
And about refusal or other information, we have no knowledge.
Nothing is it. Because the procedure has been followed. You commence there is nothing on record to show that you dispute that procedure. I'll have to look into the procedure, whether you don't participate. How can I hold them?
Petitioner has already filed a representation before the director and before the governing body.
There is no
So we
order
got
staying.
No.
Is there any order from this court staying these proceedings?
That dismissal order, there is a procedural stay, Lordship. In this case, there is a stay, Lordship.
Hmm?
In this case, there is a stay, Lordship.
Stays there.
Yes.
Is continuing in school.
No, Lordship. He has submitted the certified copy of this order before the college and thereafter he did not attend the college.
Where have you brought that?
No,
on record?
Lordship, that's because that is not the, they have not challenged, they have not filed any IA that it was not complied with. So it is not necessary on our part to bring it on record.
And Mr.
It was 20.
Mr. Counsel,
Yes.
this order was passed. until
At the
further
initial
orders.
stage, that's because the facts was concealed.
Be that
that-
as it may, why did you not file an application for vacating this? Legally, he is there.
No, Lordship, that
Is that-
order, Lordship, had there been any violation of that court's order, he should have filed.
Fine, I get it, because this order is not over. It is with me now. Now you tell me why did not be deemed that he was in service.
Then I will bring it by way of an affidavit. By way of an affidavit, I will bring
File
it.
it,
Lordship,
file it, because this order staying,
order is there.
order is there, how can I go beyond that?
No, Lordship, but he challenging his.
He is not saying that. I am asking you,
No, Lordship, I
my
can
order.
bring it on record, but whether that is useful,
Yes.
Lordship, as because.
what happened? After this order,
After this order, petitioner, as per instruction, petitioner going to join the service, his service, but he was protest,
from 18 onwards, he is daily going, not,
not really going
Then
because they
why didn't you file a contempt?
Yes, Lordship, he should have
we
been.
have not filed for that because on that after that, Lordship,
You are not interested with the
This-
job.
it
With
was
this order, which is a rarity, seeing the circumstances, this court had favored you with an order, given you an order. Why have you not utilized that?
it's going to, but they
It's a
have.
total concealment of facts, Lordship. He has refused
Allow me
the
to file
letter.
my
That
affidavit
was
he
never been got
going
in
to
the
file-
petition because
going
of
to
that
join
the
the
interim
service,
order,
Lordship.
Lordship.
You consider? We will fix it for
Allow
delivery of
for
orders.
2 weeks time to file.
No.
1 week, Lordship.
That you file in the education tribunal. I'll not dismiss it. I'll say you go before the
Lordship,
education.
Lordship, that would be better as because certain disputed question facts are there, Lord.
List it again on 13/2/2024, on which they, for delivery of orders.
Lordship.
Hey, to file to now.
Either with the allow me to file affidavit, Lordship, of that.
Lordship is fixing on
13/2.
13 to
No
Lordship.
affidavits, finished.
Much obliged.
Obliged, Lordship.
Item 25,
This case, I have the instruction to withdraw this petition.
Huh?
But I have the instruction not to press this petition.
Why?
But the petitioner has already declared from his service.
You are for the petitioner, Panchandra Kulta.
Yes, madam.
I'm for the private respondent, your lordship.
Huh?
I'm for the respondent, the private
know.
respondent. The affected party.
On the prayer of Mr. I.H. Suike, Mr. I.H. heard Mr. I.H. Suike, the counsel for the petitioner, also heard Mr. M. Sharma, learned counsel appearing for the respondent number 4, and Mr. U. Sharma, learned standing counsel, secondary education department for the secondary education department. So Mr. I. Suike submits that he is under instructions not to press the writ petition. He is under instruction from the petitioner not to press this instruction any further, in this writ petition any further. Also accordingly, the writ petition stands dismissed as withdrawn.
Obliged.
Any interim order, your lordship?
Any interim order passed shall stand vacated.
I'm grateful.
Interim order, if anything, shall stand.
I'm grateful.
Item 26.
Yes, madam. Any development?
Yes, your lordship, as per your instructions, we have applied for the RTA. And fortunately, we got the report also, your lordship.
It is Barbarua T Estate LP School.
Yes,
It's a provincialized school.
but the salary as per the instruction that the affidavit I filed.
Madam, you
only
bring
two
this on
teachers.
record by an affidavit so that he can counter this. Now your case comes in there. Now she has a case.
Because that only the.
Say
only
this,
two-
I don't know, dispute this. This is something from the PEO.
That the copy should be
Sure,
furnished to copy so that
Madam,
I can.
Two-page affidavit, bring this on record, give him a copy. On the next day, have your instructions.
That
We'll have it on 16th
16th
or
lordship,
15th.
lordship, that's. Can it be lordship on
16th is. okay.
21st?
21st, no problem. Miss S. Sharma, learned counsel, has furnished to this court an RTA reply received, which shows that the school, that is Barbarua T Estate LP School, wherein the petitioner claims for provincialization of her services, is a provincialized school and not a school under the management of the Barbarua T Estate. Mr. You counter this? Oh, you counter this?
Yes, lordship, because I have that instruction.
Hmm?
Clearly, only two teachers salary, they have two have been employed. That's why last occasion I filed, submitted that document, lordship.
Hmm.
There's still this,
So and so appearing for the Barbarua Tea Estate shall submit his stand in the matter. Full stop. To facilitate the respondents to bring on record their stand, Ms. M.S.S. Sharma shall file the RTA reply by way of an affidavit within a week from today.
the goal.
List this matter again on 21/2/2024.
At the time that they have also furnished some. I will,
You satisfied?
yes,
Because the only issue why we were against her was your contention that this is a school of the management.
management, lordship.
And government had given 2 teachers.
Yes, two.
Now the
two
government
students.
is saying that it's a provincialized school.
How that.
That's for you to,
Yes, your lordship.
So in that regard,
That's for you
affidavit
to say.
document is submitted.
that's for you to say. Come on, you bring on record.
Lordship, I will take.
Item 27.
Yes.
Departmental evidence is required.
In this last occasion, department also took time for filing affidavit.
On the prayer of both of the prayer of the parties, list this matter again on. List this matter after 3 weeks. So on a date to be fixed by the registry, Ms. N. Fukan in the meanwhile, shall bring on record the stand of the departmental authorities in the matter by way of filing an affidavit.
Supplementary list, item 45.
You want to?
My lord, on the last occasion, my lord, I was asked to furnish decision in support of my case that is regarding disproportionate punishment. My
Where is Mr. Gogoi?
Is there?
Oh, you are there, Mr. Das is there. Okay, no problem. You are there, it's fine. Mr. Das, where are the records?
Yes, my lord.
Records. Madam, just have your seat.
Yes.
The original records has been misplaced, my lord. Therefore, some of the records has been collected from the school. And
Where is the show cause?
my lord, the show cause notice is not traceable, my lord. My lord,
Who issued it?
the college authority.
How?
Because
How?
some complaints were received by the.
Okay, fine. How can the, who is the disciplinary authority? You are the disciplinary authority. How can the college issue that notice?
So that was preliminary inquiry, my lord.
Huh?
Preliminary inquiry.
Where
was
is
done by
that
the
main inquiry?
main inquiry has not been done, my lord.
Huh?
That as per records, that has not been done, my lord. Main inquiry.
Then how come the penalty was done?
This one. Because if my lords had the impugn order, my lord, suspension order, it says that as per the resolution of the governing body,
Come to page 31, 32, writ petition.
yes, my lord.
Okay,
Yes, my lord.
this is the order of the disciplinary authority, right?
Yes, my lord.
And he has been removed by this. I want to know where is that show cause issued preceding this?
Proposed by the department, my lord. That is.
Director.
That is.
Rule 8. No authority other than the director can issue the proposal. Yes, madam. Where is the show cause?
My lord, no show cause notice was issued.
Where is your statement to that effect?
My lord's statement is there, my lord. Subsequently, departmental inquiry by letter so and so.
Okay, fine. Departmental inquiry, everything we understand.
Yes, my lord.
Where is the show cause? Give me the show cause.
But during inquiry, the notices were served
You
upon
tell
the.
me about your statements where you have said
At page, para 5, my lord. The petitioner begs to state that subsequently departmental inquiry was held.
I'm not on the inquiry, madam. So you accept that the show cause was properly served. You accept we are not proceeding in that
My lord,
way.
during inquiry, the notices were served upon the petitioner to appear, my lord. Prior to that, no notice was served to him, my lord. I have my lord, I stated at page 7, the first sentence, my lord.
That is with
It is
regard
not
to your
that no
suspension, madam.
notice had been issued to him.
Yes, what is it? What is the position? If no show cause was there, subsequent actions become, because he's a government employee, subsequent actions become non-existent.
But in this case, my lord, my argument will be that that there is an alternative remedy, my lord, for the petitioner. Alternative remedy, my lord.
We are not going into it. When the whole proceeding is without jurisdiction, what is the question of alternative?
No, my lord, rightly or wrong, if I say, my lord, rightly or wrongly,
We'll interfere.
some order has been passed, my lord. And for that order, my lord, the petitioner has alternative remedy which is provided under this, my lord.
Where is your
statute, my lord.
affidavit? Yes. Now from your affidavit, show me. So this show cause notice that is reflected in paragraph 5.
Right, my lord. It was sent by the college authority, my lord, principal. There was some complaints were received by the.
So this
students
is
and
preceding the suspension. This is pertaining to suspension.
Yes, sir.
Charge. Where have you drawn? Where is the statement? You can't deal with him in such manner. Show me, I'll be satisfied. Your whole affidavit pertains to suspension order. Nothing to do with the department. Madam, you are also not assisting.
My lord, prior to suspension, no show cause notice was issued. During inquiry, the notices were served upon the petitioner, my lord.
Where have you stated that?
That is, I have stated at para 5, my lord. Para 5, at page 7, my lord,
Madam,
page 7. Then the petitioner also submitted his reply, my
no, not
lord.
on that. Where is your statement that there was no show cause notice given?
My lord, at
You
page-
have not submitted any reply.
Page 7, my lord, first sentence, my lord.
That is, madam, with regard to your
Suspension. Yes,
suspension.
ma'am. Subsequently, my lord, at para 5, my lord, that during inquiry, the notice was served upon the petitioner to appear before the inquiry committee on the date fixed for cross defense, my lord. But the petitioner could not appear before the inquiry committee due to his
So you
severe
are
illness.
satisfied with the inquiry. Only
No, ma'am.
question is you are questioning the
Punishment, my lord.
punishment.
Yes,
Okay,
my
fine.
lord. And
So
we
shall I
have
record
also-
the fact that you have no grievance with regard to the procedure, only the penalty?
Error is also there, my lord.
You have not said, madam. You have not said. In spite of my bringing it on before your notice, you have not said.
And before, my lord, imposing punishment also, the petitioner should have given a notice, my lord. That notice is also not been served to him, my lord, issued to him.
So you will be satisfied if I direct them to give you the inquiry report and then
And-
close the matter?
Regarding, my lord, here, my lord, only on in respect to disproportionate punishment. Your lordship may kindly see the allegations, my lord. At page 23, my lord. These are minor, my lord, allegation, and the dismissal is a extreme punishment, my lord.
Madam, for a teacher, I think this is the enough. These allegations are enough. Not teaching, irregular, not enthusiastic in taking classes, not explaining clearly. Very
And this was because of-
non-cooperative,
Yes, my lord.
not obeying the principal governing body,
And the impugn
and
order.
not giving lecture afternoon going home.
Some
My
complaints are
lord,
also
the
there, madam.
impugn order
Some
contains what,
complaints are also there, madam, written by the students and
my lord,
there are
impugn in order contains one additional allegation, which was not there initially, my lord. At annexure E, my lord,
Madam, where is that statement of yours?
and my lord.
You do
before-
one thing, like
and
this, we can't do matters.
My
You-
lord,
You
before
prepare it
issuing-
in a seriatim. Then
Before
come.
issuing, my lord, the dismissal order, also, my lord, the petitioner should.
No, this will
have,
not do, madam.
Issued a
You
notice, my lord.
you come from
He
the
should have-
top. Otherwise, we will not be.
He should have, my lord, given an opportunity, my lord.
On the prayer of Ms. S.B. Chaudhary, learned counsel for the petition, list this matter again on 15/2/2024. Ms. Chaudhary is to submit a written argument on the said date, highlighting the points she would like to urge before this court.
Yes, ma'am.
Because say one here, say that, it gets confusion from
Yes,
you.
my lord, I'll submit a written argument.
liberty.
Are you for you also? Parties will agree. Parties are at liberty to submit their respective written arguments, highlighting the points that they would like to argue before this.
Much honor.
And try to find out that whether it's there or not. She has not argued, so let's forget it.
Yes, sir.
Daily list for order item 29.
Obliged.
Yes,
Last
Your lordship, we did not contact with the client.
on the prayer made on behalf of the learned counsel for the petitioner, list this matter again after 3 weeks on a date to be fixed by the registrar.
Obliged.
Come back at 2.
My lord, item 30, my lord.
Hmm.
This is the next item, my lord. May I pray for a little accommodation for next week, Tuesday, my lord?
Where is Mr. Doctor?
My lord, my friend is there, my lord.
Okay, that 31/5/2017
My lord.
till date and 31/5/2007, that letters.
Oh, yes, yes, my lord.
Mr. Doctor, I think appears.
Yes, yes.
List this matter again. After we have specified only graduation with DL.
Yeah, DL, yes.
We have specified that.
Yeah, that is what is.
That's why I got a bit late.
Yes, yes.
You'll get the order. I'll go down and I'll sign it.
Applies here.
It'll be uploaded today.
Yes.
No, pick it up electrically. Tomorrow, Kali Rati ko gusto ko. 42, 22 did issue. Aji fix course will be. I thought. How much did you do? Matter.
Daily list for orders item 31.
Mr. Bhatti, you have that matter. Your opposite party is here. Oh, yeah. We'll just finish up a few and then we'll come back to you. Please.
Kindly peruse the last order, 1512.
Yes, Mr. Khatonia, what happened?
Already proposal was submitted to the Finance SIO Department.
Okay.
A proposal was submitted to the Finance SIO Department to create a post, my lord.
That was the instruction you gave me last time.
That is the latest instruction on 31/2024, my lord. That is, I have received the instruction. Thereafter,
Okay, we'll give you one more date, no problem. On the prayer of Mr. N.J. Khatonia, the council preparing for the respondents, list this matter again on 26/2/2024, by which date the respondent shall place before this court the compliance order. I'm out.
oblige.
Item 33.
32 to adjourn. 3 weeks. 3 weeks, 26/2. Yes.
That matter, my subject. Yeah, my lord, naturally in the case is that, my lord. So petitioner is, my lord, BA, BSc, BEd, and TET qualified. I have filed to that effect, my lord, additional affidavit, and case was not considered. Only ground that, my lord,
Subject only.
they said, my lord, mathematics, those who are having mathematics, they would be considered, but there is no such specific as in the available in the law. My lord. And there is also, I have found, my lord, there is a 3 persons can given matter. But law is not that clear. And government has also not filed an affidavit, my lord, who is the best.
No,
person.
nobody has been provincialized.
My lord, others have been provincial.
Only this post is.
This post.
Science post is kept vacant.
My post is not.
Vacant by virtue of the High Court order.
Litigation.
There is a, my lord, series of orders, my lord, at the last occasion also we moved.
You are a biochem.
By
You are, and he is
Royal.
right.
amongst you who is senior.
I'm the same.
You are senior.
To that effect, my lord.
Yes,
before-
madam. What is your stand?
2017 actually.
2017 Act does not specify the, does not say.
110, your lordship, 110, your lordship.
What is your stand on that?
We didn't file a affidavit,
Why?
but according,
They are fighting, you also should come in. You should clarify, because if we pass an order, you will be in trouble. We can pass an order by hearing them. But what is your stand? Whether it would be science seniority,
yes.
or
your
you will
lordship.
have to go to the subcategory of maths, biology, chemistry, like it is a subject teacher post.
There should be one, your lordship,
Hmm?
one subject teacher, your lordship, according to the education manual of 110, your lordship.
Madam,
7.
this is a very serious issue, I'm telling you. If you don't want, we will proceed, don't worry. But they have brought in record materials, both sides.
Only government is silent, my lord. Who will be the best person, my lord?
That,
I got, my lord, 4 degrees at a time,
and I'm
including
telling you, I have been
graduate degree.
seeing this thing. It's not consistent. Yes, Mr. Kaushik. you are sitting. It is not consistent. In some cases, you go with the chemistry, whoever is senior in science. And some cases you go with, if you find that the maths teacher is junior, you go say, no, we will have to have maths to teach this. Where is the policy?
2017.
Where is the policy? We had heard this matter at length. Then he wanted to file an additional affidavit.
We filed it.
That got the matter delayed. Otherwise, I was on that day ready. Any decisions, Mr. Any decisions?
Decision is not as such, my lord. The problem has created, my lord. Though it is in my favor, lordship kindly turn to page 95.
95 of this.
Page 95 of my read petition. Yeah, my lord, what happened? Honorable court already held, my lord, coordinate bench, last paragraph, my lord. Since the case of the petitioner is pending before the state level committee, court is of the opinion that no such fresh decision or order.
No, that was in terms of the earlier orders.
My lord.
There were earlier orders.
Earlier order is still in force. And they said, my lord, what are they-
In 2011 Act, there is division
but
by
here
service.
we have to consider it in terms of 2017.
No, my lord, the
17.
case was decided on
In
Because
2011 Act, you said nothing doing,
nothing,
seniority.
only seniority, no combination.
So
That
we'll
has been-
apply that here. Then Mr. Gugoi will not like it. Yes, Mr. Gugoi, you have any decision?
My lord, actually, my lord, this act is, the 17 act is, my lord, clear, my lord. For, my lord, one core subject, one teacher will be there.
Okay.
Mathematics, there are four subjects is defined as mathematics, science, English, ML, and social studies.
Where are you reading this?
110, my lord, 38, my lord. Roman 8. Roman 8.
No, yes.
So already science, another science teacher is there.
No. You are a ME or a high school?
High school, man.
High school.
High school.
The third line, my lord.
Third line. In case
So
of
now
eight
tell
others.
me one thing, Mr. Soikia. Mr. What would be the meaning of this word mathematics, science?
Mathematics is the different. There is a
Science.
comma. Science is different. English,
So
ML,
science
and
will
social.
encompass
These-
what?
these
No, science will encompass what?
Science will, my lord, encompass, then, my lord, we have to go to the SEBA regulation. SEBA regulation. I have got it.
It's on record, yes.
Yes, my lord.
Take me to that.
Several
Subject
regulation,
combination
it has
is
been
there, my
interfered.
lord.
It has been interfered.
No,
But
earlier, my
for-
2011 Act, 11 Act, my lord. Now, my lord, after 2017 Act, this regulation would be applicable. So, this is the regulation, my lord.
What is the difference between the length of service between you both?
My lord, I joined 2 days before,
2 days.
3 days before.
1 or 2.
And difference is that, my lord, I got BA, BSc, B.Ed and TET. 4 degrees. And so far RTE is concerned, my lord.
My lord,
Those who
lordship kindly-
qualified TET, my lord, they are best entitled.
Page 7, my lord, teaching staff, my lord. Then, my lord, graduate teacher, lordship will find. Headmaster, BA, BCom, BSc 2. Then, lordship come to at Roman 2. The subject combination of the BSc teachers shall be such that all the BSc teachers taken together shall cover 6 weekly periods of mathematics, 2 periods in physics, 2 periods in chemistry, and 2 periods in biology.
Okay. Now,
Then,
if
my
I have
lord,
to follow this with one teacher, how can I require you to teach biology?
no, my lord, only biology teacher is there.
Show me that regulation
Yes.
order, provincialization order.
Lordship kindly come to my IA. Page my number, my lord. 36, my lord. Ojit
I
Sang.
will see
Ojit Sang.
1616. Right. 1616. IA number?
IA number 1616.
Where you want
Come
me
to
to?
page number, my lord. I'm coming, my lord. Page number 32, my lord. This is the DLC. two biochemistry is there, my lord.
Where?
Page 33. Lilavati Gogoi, headmistress of Mohiral Bohumukhi High School, has stated that, my lord, there were two BSc teachers working in the said school, Ajit Sangmai and Chitralekha Konwa and Konindo Sangmai, in order of seniority. In terms of qualification, both Ajit Sangmai and Chitralekha Konwa belongs to BSc Biology category, and Konindo Sangmai belongs to BSc Royal category. I am the only royal teacher.
No, but you said there is some other teacher engaged.
Yes,
there.
yes, my lord. That is my lord Ajit Sangmai and Chitralekha Konwa. Chitralekha and Ajit Sangmai. Both are and Chitralekha Konwa.
And between Ajit Sangmai and Mr. Barbia, who is senior?
I'm the senior.
No, Ajit Sangmai is senior.
Ajit Sangmai is not relevant. Ajit Sangmai has been provincialized.
Where is that order of provincialization?
That I have annexed in my read petition, man.
Not seen it.
At page most probably 57. In the read petition, I have annexed my page 67. 67.
Yes, sir.
Process to the common letter dated so and so, whereby the so and so.
Ajit Sangmai.
Ajit Sangmai, serial number 5. And 6 is vacant.
He is this biochemistry committee.
5 is biochemistry and 6 is royal. So royal bio issue was there. So
The provincialization did not say anything, my lord.
it was vacant, my lord, due to High Court case was pending, my lord.
Only science graduate. My lord. Bio royal has not been mentioned.
See, in your school, maybe one bio is there. There may be a different situation in a different school. We can't base our decision on one school.
Yes.
It has to be on the terms of the rules.
But 17 Act, my lord, says one teacher for mathematics, my lord. 17, my lord.
17 does not clarify.
No, it is clear, my lord. Page 110, lord, you can see.
So here you will require 1, 2, 3, 4, 5 teachers.
5 teachers. So one mathematics, one science, one English, one ML.
So the science teacher will teach other than mathematics all subjects.
My lord, it is
Other than mathematics, all subjects. Not all subjects, it's science subjects.
no, my
So
lord.
biology, and chemistry.
9 it
and
is
physics.
Roman 9. It is written by the provincialization of service
bio
of
person
additional
can't teach
teacher.
physics.
My lord, bio person can't. My lord, the royal person will teach my lord physics and my lord this mathematics.
So if we go by this
Seva regulation.
SEBA regulation.
Yes, my lord. Then my
What
lord,
is Seva regulation?
royal person will teach my lord mathematics and physics, my lord.
Okay, you come.
Seva regulation, my lord, page 8. Below page number. The subject combination of BSc teachers shall be taken, shall be such that all the BSc teachers taken together shall cover 6 weekly period in mathematics, 2 periods in physics, 2 periods in chemistry, and 2 periods in biology. So here, my lord, mathematics and physics will teach by this, my lord,
Yes,
applicant.
you have a case there.
My applicant. And
Yes, Mr.
My lord,
Madam. What is your stand?
I go with the regulation of 2017, your lordship. That is the only stand, your lordship.
You have your instructions, madam. Just the written instruction will do. No need an affidavit. As to how they are doing it, I want to know that.
my lord, one thing I like to clarify, my lord, lordship lordship is on page 110, my lord. 110, Roman 9 says something contradictory. Why it is, lordship kindly have a look for provincialization of service of additional teacher or tutor, as the case may be particular subject, including core subject. Meaning thereby, my lord, other teacher also can be provincial.
No, it is depends on the enrollment. If the
my lord,
enrollment is more,
enrollment it is there, my lord.
if
More than
enrollment
my
is
lord
more,
necessary.
if they require a social studies teacher more, they can bring it, but they'll have to satisfy the enrollment. Mr. His argument referring to the SEBA regulation. SEBA regulation also requires 2 teachers for science, BSc.
Well, the SEBA regulation, I have not come across, man.
He'll give you a copy.
Yes. I'm giving him a copy.
It can be one document because for recognition of your school, first you have to go to SEBA.
Yes.
SEBA has recognized your school.
My lord.
Now, if that be so, if that is to be, if this provision is to be understood with regard to core subjects in mathematics, science, all, because this line was not there in 2011.
My lord. My lord, apart from this, my lord, lordship, my argument is like that, my lord. I am BA, BSc, BEd and TET.
No, it will
Lordship,
depend.
for a moment, my lord, for a moment. If I am TET, my lord, I am simply graduate teacher. Graduate teacher means if you go by right to education act, my lord, those who is a graduate, he has to teach science, arts, commerce, everything.
My lord, page number 106, my lord. Section 210, my lord. Hansard High School means high school imparting education up to class 10 and established by the people of the locality prior to 1/1/2006, which has received permission from the state government and recognition from the Board of Secondary Education Assam.
That recognition
And
we are not on.
so my lord, to get the recognition from the board, my lord, math teacher is my lord.
So that is one way of interpreting it. Second way is follow the decisions of this court in relation to the 2011 Act.
11.
Then Mr. Bhuya's client will come. But the only difference, see, a line makes a world of a difference between two statutes. In that, this prescription was done.
Now, by 2017, as per statute, my lord, 2017 Act, my lord, mathematics teacher is compulsory. As per
Page 95, my lord, for a moment taken into
Mr. Bhuya, you said you are a BA, BSc and all.
Yes.
Do you have mathematics?
Mathematics, I do. But I am the TET qualified. TET qualified meaning thereby, my lord. I am qualified as a graduate science
You are
teacher.
qualified to teach kids.
If I am the graduate science teacher, my lord, so I have to teach all the subjects.
That
It is not
qualification,
particular.
my lord,
It
tutor
is
or
not
teacher,
the
that
case,
is.
my lord. The maths teacher will teach only maths. It is not there. Lordship will have to see the syllabus of class 10. If the government can place the syllabus, my
You
lord,
can place from your school. What is preventing you to place it? You can place it.
I can, but government will be authenticated.
You can show in the whole week only one mathematics class is to be taken.
All lordship can pass a direction, my lord, not from this particular school, asking the government department
No. You bring it from your school. I believe you. There is no problem.
whether I'll get or not, my lord, since
Why?
headmaster is against me.
That routine is there for all. You can just click it, get it. It will be there for with all students.
Routine.
Yes. We put that line.
That can be.
And then
I
write-
can, my lord, brought it through WhatsApp message after sorry to lordship. Allow me to 15 minutes time, man.
No. We can allow you. Madam,
But government
we are
has to take
fixing this
stand.
matter. Basically, now I'll have to take a call between the 2011 argument that you have developed.
My lord,
Basing on that
page
judgment
95, my
or
lord,
his-
his lordship passed order on 21st, my lord. More after the new act has come. Page 95 was disposed of by passing order on, my lord.
No,
passing-
anything now happens will happen under the 2017 Act. We can't go beyond
No, but that is true, my lord. But
The judgment can be used to interpret this.
my lord.
But the problem I am
judgment
facing
taken,
is,
my lord, 221.
when can you have your instructions?
After 2 weeks,
2 weeks, my lord.
I'll forget. I've already forgotten.
1 week at your lordship.
Only that
Yes,
aspect,
your lordship.
how you are approaching.
Government, including
And that should be uniform for all. It should not be case specific. It should not be case specific.
And on Wednesday, your lordship.
My lord,
On
one
hearing
more thing,
day, my
my
lord.
lord, I like to, I like to make one submission, my lord. Who is the best person?
That
I am,
we
no,
are
my
not.
lord. I am having 4 degree, including TET.
That is
That degree, Mr.
No, my lord, TET qualified
not
is not a matter of,
Translate to,
my lord. TET we have to qualify. Nowadays, my lord, TET is a mandatory for all these things. And this is the high
only
school.
difference can make is maybe if you have TET, you will get a teacher post. He does not have TET, he will get a tutor post.
My lord,
That's the only difference.
but I am TET qualified, my lord, I cannot teach.
Miss, H. Jaranpi. shall, Standing Council Elementary, Secondary Education Department shall place before the court on the next day the stand of the respondents with regard to the filling up of post of assistant teacher science in high schools in this high schools in the high schools on provincialization on provincial for the
It is
purpose of
already
provincialization of services of such. No, क्या लिखा है? No, ऐसा लिखो with reference to the method followed by the authorities for filling up of the 2 posts of assistant teacher science on provincialization of a venture high school under the Act of 2017. Such instruction shall be so given to Ms. Terangpi by the respondents with special reference to the provisions of
And connected laws also.
3(8) of the Act of 2017. पूरा लिख दीजिए. Okay. You'll get the order today uploaded. We'll fix it on 13th.
May I pray after the motion admission?
You make a mention at 10:30.
Oh, Lordship can fix at 2 o'clock, my lord.
No, I don't know how it is because top of the matters are there. That has to be given.
Yes. My lord, one thing Lordship has to add, I think, my lord, section, subsection 8 and 9, my lord. 9 also says.
No, let it come. Let it come.
And connected laws also, my lord. They have to take care.
You let them come. Let them come. Let them come. But that's.
Lordship may keep the regulation in the report.
No, you can take it back.
And in the meantime, my lord, I'll obtain their syllabus as well as the routine. If necessary, we'll file the additional affidavit.
No need to, you just give it to me, man.
An interim order to be continued.
Interim order regulation.
What action list for motion item 1?
13 तारीख ना 13 तारीख मंगलवार को. May please your lordship. My lord, tomorrow is the date, last date for submission of application, lordship. Lordship, main fact is that lordship petitioner passed her HSLC lordship from Kendra Vidyalaya lordship, wherein the medium was instructed.
You show me which is the offending, what do you call that? Eligibility criteria in the advertisement. Offending eligibility criteria, that is against you.
Yes, lordship.
Which one?
Lordship, I have lordship annexed the notification issued by the NCC of the wherein it was clearly mentioned that lordship BSc with BEd along with TET lordship. So there are no such criteria lordship laid down that medium of instruction regarding lordship. But in the advertisement lordship, there is a restriction which was imposed lordship that medium of instruction should be as per school's medium of instruction.
We had challenged this. I think he withdrew it. Thereafter, I don't know what happened. AG had appeared. That seat at what happened to that matter? Withdrawn, I suppose. Withdrawn.
On that context, that the seated candidates are getting a preference.
That I think he withdrew it. He withdrew it.
Here, my lord, he is challenging clause 3 of the advertisement at page 49.
I know it, but match the medium of instruction of the school where the candidate wishes to apply. Yes, what is your grievance with regard?
Lordship, my grievance is that lordship, due to that clause lordship, while I going to submit my online application lordship, while I put that language 1 and language 2 of TET, CTET and ATET lordship, Hindi and English lordship, that my application was not accepted lordship. Although lordship, I have obtained the 1-year diploma course lordship in Bengali language as from the Barak.
Yes, Mr.
Lordship.
Hello.
You take instructions.
I'll take instructions. Otherwise, my lord, this page 23, this is the NCT regulation, my lord.
No, his case is that he is not being able to upload.
No, why he is not able to upload? Because he had language 1 in the Assam TET, Hindi and English.
Where?
His seated certificate, my lord, will find.
Lordship, at page 29 is the seated
Page,
certificate.
yes, page 29.
Language one.
Language one, English,
English.
language two, Hindi. Now, if he wish to choose the Bengali medium school, he cannot.
And you have a Assam TET also,
Assam TET also. And the Assam TET also,
same.
same, page
Same.
30, English and Hindi.
Then
In similar circumstances, Lordship, this honorable court already in the year 2017 for high school teachers, Lordship. That Lordship.
my Lord Justice Medi's order.
Yes, Lordship.
I
That was
appeal.
Tahanara Rahman.
My Lord Justice Medi's order.
My Lord Justice Arup Kumar Goswami.
Okay.
That I have annexed, Lordship. Page 31 starts from page 31, Lordship. That was negated by this honorable court, Lordship.
That was an office memorandum issued under the 2003 secondary rules.
Operative portion
No,
starts.
this is with regard to your that.
Office
It's
memorandum.
not with regard to L1 language one.
No, no.
School, it's not with regard to that.
Regarding
with
medium of
appointment of-
instruction, Lordship.
Hmm?
Medium of appointment in the Bengali language or Lordship Assamese language instruction schools, Lordship. That is regarding, Lordship, because that notification was issued restricting the Lordship candidates who had qualified in the CTET as well as ATET, Lordship, having the Hindi and English as a language.
And tell me one thing, this advertisement was issued on
23, Lord.
23/12.
Yes, Lordship.
Why are you here today
Lordship,
on the eve?
because while Lordship, January, Lordship, I am going to apply, Lordship, because there are no
Sir,
such.
you have your instructions.
I'll have my instruction.
We'll take it up on Monday.
My lord.
Don't worry, they have extended it till 10.
Lordship, tomorrow is the
12,
last day.
10,
for-
10,
We have extended it till 12.
12,
12.
10 PM of 12.
12. Lordship, tomorrow is the last. day.
No, no.
That last date
extended.
has been extended till 12/2/2024, night 10 PM. He's having some apprehension. Do you have that communication?
12 তারিখে extend করে দেওয়া হয়েছে।
Also, the Mr. B. Kaushik, Learned Standing Council, Secondary Education Department. No. Elementary Education Department shall receive his instructions with regard to the grievance raised by the petitioner pertaining to clause 3 of the advertisement dated 26/12/2023. So it is to be noted here that in a separate proceeding, this court was informed that the last date for submission of the applications in pursuance to the said advertisement has been deferred from 02/02/2024 to 12/02/2024, night 10 PM. Also, list this matter again on 12, no, on 5/2/2020. Yes, right, he is also entitled covered under that.
My lord, yes.
5/2/2020.
I look.
You get your instructions.
I'll go. In fact,
And there is, I think, 2 orders, one by the division bench and one by my Lord Justice Medi, wherein this clause that you can apply only with regard to the language you have was interfered with. But whether it will applicable here or not, I don't know, but you can make a search for it.
and this clause, my lord, has come because of the NCT regulation of 2010.
What is that?
In fact, your lordship will send me the page 23.
Page 22, 23
Page
is the.
23. B, my lord will find.
B.
Pass in TET eligibility to be conducted by the appropriate in accordance with guidelines framed by the NCT. I'll place that guidelines, my lord.
Okay.
That guidelines clearly says that language one means he has to have a proficiency of that language and the medium of instruction will be that.
That's the, but proficiency of the language,
And medium of instruction. Both
hey,
are there.
he wants to be an English teacher. then naturally he'll go for TET with that qualification, other way to look around it.
Yes.
So that he has the proficiency in the language he will teach. Similarly, Hindi. To teach Hindi, he must have that provision. I can understand you putting a clause that you must know Assamese, Bodo, or Bengali.
Yes.
You can restrict his appointment to that but this also you examine. Whether that can be interpreted to mean that also.
Because here is the case when he wanted to apply in a Bengali medium school and he doesn't have the Bengali.
We'll see on Monday. Let him get his answer.
All right.
Hindi hole পারে না?
For orders, item 46. Timing item 7.
Well, only I want to show your lordship page number 25 and 26 of the affidavit in opposition. Filed by
Page number
25 and 26 one.
affidavit of whom?
Opposition for respondent number 141.
No. Who first filed it?
SM Bakir.
That's a bucket.
My lord,
Just now. Page?
page 25 and 26 one. Like proposal was sent to promote freshers from my lord, district level also, who have completed 25 years of service.
When did you retire?
My lord, petitioner number 1 in the year 2014. So 30 years service completed without promotion. And other petitioners also retired. One was appointed in the year 85 and retired in the year 16.
Okay. Now tell me one thing. If that be your case,
Only promotional benefit if they, because they have sent proposal, my lord. And page number 26 also showed that, my lord, if you may mention that promotional proposal for freshers of district level.
this matter has been pending before this court. Notice was issued on 2/9. Nothing there. Daily time. Either you or they. Then, if that is the intensity you are showing, this matter should have been taken up for consideration much before. And after 2016, it is at my instance that these matters are being listed, not at your instance. But you tell me one thing, forget all those things. Without that policy being under challenge, how can I come in?
Well, here,
Just show me that.
here only, my lord, our case is that, my lord, since they have sent the proposal for our promotion, my lord. They have themselves sent their proposal for our promotion. And so, my lord, but the same did not happen, my lord. And so, my lord, as
You have not based your claim on that. You have only said it's one, set aside their thing, give it to us. In the writ petition, the structure.
But my lord, their annexure shows that they have sent the proposal.
But now you retired in 2014, 15, 16, right?
Yes, ma'am.
Now, how can I direct for your consideration? With retrospective.
Well, some there is some judgment, my lord.
Show me a decision. And you have been given ACP. You have been given ACP, Assured Career Progression Scheme of the Government of Assam. 10 years, 20 years, 30 years.
Pension they are receiving.
This will not help you because that person was promoted, but he was not given the monetary benefit. This court said, the Patna High Court said, if you have promoted him, found him eligible, pay him. There was no direction from the court. Only the monetary part the court directed. You satisfy me on that policy thing. You come to page 7 of that affidavit by the chief engineer. Hassan Bakir. So, amalgamated gradation list was of 2006. Then this happened in 2008. Then you were issued in 2010 this gradation list. You have not challenged it. You knew about it. And you have not even brought that thing on record. I would have even understood that this was done behind your back. Then in the reply, there has to be some statement that we never knew. Not even there. Sorry. Only on that point, otherwise nothing. Yes, Mr. Khatania.
Yes, Malad. There are two separate gradation lists, Malad, for directorate level and district level, Malad. We have come under the directorate level, Malad.
Was that list made to promote you all, denying them?
Sorry, Malad.
Was that list made to promote you people, denying them?
No, Malad. That is a decision taken by the department, Malad. In fact, in every establishment, Malad, there is a in chief engineer level or commissioner level, Malad, there is a separate gradation list, and for district establishment, there is a separate gradation list. In every department, health, excise, PWD, in everywhere, Malad.
Mr. Here in this case, in your reply, you have said they should not make, but they had made and you don't know. That was not said. There is a difference between both. You had not known. They had, after you filed the case, made all these things to justify the illegal. It would have been a different argument. That's not even your case. Okay, take your seats. Mr. Khatania, you are appearing for?
5 to 13, Malad.
5 to 13. And what are this? 14 to 20, nobody appears.
No, Malad.
The petition has approached this court by way of instituting the present proceedings, making a grievance with regard to an order dated 4/7/2011, by which the respondent authorities had promoted the private respondent number 5 to 13 to the post of sub-engineer tech 1. Also, the petitioner who were working as tracers in various district level offices at the relevant point of time, content that the cadre of tracers both in the directorate, that is the chief engineer's office, and in the various divisional offices was one. And in support thereof, the petitioners have placed reliance on a gradation list published on 10/4/2006 by the additional chief engineer PWD bracketed P Assam, wherein the names of the petitioners working in various divisional offices figure above that of above all of them, senior to all of them.
Senior also given, senior.
No. You are senior to all the 5 to 13, you are senior.
5 to 13, I am senior. Malad.
Okay. Wherein the petitioners have been denoted to be senior to the respondents number 5 to 13. Full stop. It is the grievance of the petitioner that the cadre being one, the respondent authorities could not have proceeded to issue the order dated order dated 4/7/2011, promoting only the tracers working in the office of the chief engineer PWD Assam, Roads Assam, to the post of sub-engineer bracketed technical, ignoring the cases of the petitioners. Full stop. The petitioners contend that the promotion as affected in the cases of the response number 5 to 30 were so affected without even considering the cases of the petitioners hearing, in spite of the fact that they possess all the requisite qualifications for such promotion and were in fact senior to the person so promoted. Also, the respondents have filed affidavit. The respondent authorities have brought their stand on record by way of filing an affidavit, wherein it is contended that yes, earlier the cadre of razor, both at the level of the chief engineer's office as well as in the various division officers were considered to be one cadre. However, in the year 2018, a policy decision was taken wherein the government had required the fixation of seniority, about the fixation of seniority of each tracers separately at the director and the district level. Also, the said decision was communicated to all via a communication dated 10/7/2008. Also, thereafter, from the materials available on record, it is seen that separate gradation list for the directorate office as well as for each of the divisional officers were being published regularly. Also, the names of the respondents number 5 to 13 figuring in the gradation list of the directorate, they were so considered for the vacancies of the cadre of sub-engineer, junior, sub-engineer grade 2 bracketed technical for such promotion, and while order dated 4/7/2011, they were so promoted. Also, the petitioners in the writ petition have not essayed the said policy decision to prepare separate gradation list on the cadre of races, both in the chief engineer's office, that is the directorate level, as well as the various divisional offices. Also, the petitioners, although being in receipt of such gradation list prepared from time to time, had not assailed the same before this court in the present proceedings. Also, the petitioners, having not assailed the said policy decision as contained in the communication dated 10/7/2008 and the subsequent separate gradation list being prepared from time to time by the authorities from us, this court is not in a position to interfere with the promotions as affected in the case of the respondents number 5 to 13, basing on such policy decision. The petitioners in their affidavit in reply has also not disputed the existence of any such, disputed the existence of such policy decision and the preparation of separate gradation list. The only contention being that the preparation of the second separate gradation list is illegal, and such contention was so made without putting the policy decision in place to challenge. The respondent authorities having decided to the manner and method for recruitment is within the purview of the respondent authorities, and if it is not demonstrated that such a decision taken with regard to the with regard to a manner of promotion, manner of recruitment to any post from us, it is not open for this court to interfere with such policy decisions. Also, in view of the above position and also considering the fact that the petitioners in the meantime have all retired from their services on reaching the age of retirement, this petition stands closed. I'm not dismissing it, closed. Right. But Mr. N.J. Kalpunia for respond number 5 to 13. Okay, number. Even number is into No, Mr. I told you. Madam, anybody appearing for PWD? No. None appears for the PWD.
Obliged.
Obliged. Sorry, Mr. Talda, can't help you.
Item number 1, for delivery of order.
If there is any factual inconsistency, just tell me. But Mr. P.P. Dr. Learned Counsel for the petitioner also heard Mr. U. Sharma, Learned Counsel, representing the respondents in the Secondary Education Department, also heard Mr. M. Nath, Learned Senior Counsel. Mr. Bora was there. Should I put your name?
No.
Mr. Bora, assisted by Mr. D.P. Bora, Learned Counsel, appearing for the respondent. Also, the petition. Mr. P.J. Fukan, Learned Standing Counsel, Guwahati University is present. You are the arbitrator. The challenge in the present proceedings, the petition by way of instituting the present proceedings has put to challenge an order dated 9/12/2019 by which the respondent number 4 was promoted as headmaster of Dumini Suki Girls High School. Also, the said order was issued by the Director of Secondary Education Assam in pursuance to a process of selection. Also, the facts requisite for the purpose of adjudication of the issues arising in the present proceedings is noted here in below. Also, the petitioner was appointed as an assistant teacher in the intermediate scale on 28/9/1988. Also, in Dumuni Suki Girls High School. Also, thereafter, he was authorized the graduate scale of pay with effect from 1/12/1993. The respondent number 4 was also appointed as an assistant teacher in the same school in the intermediate scale of pay with effect from 23/1992, and he was also authorized the graduate scale of pay with effect from 1/12/1993. Full stop. The petitioner had, with permission from the inspector of schools and as well as the headmaster, said school in question, proceeded to pursue his B.Ed course in Sipaja B.Ed College, and on completion of the said course, the petitioner was in the year 1995 conferred with the B.Ed degree by the Guwahati University. Also, on a vacancy arising in the post of headmaster of the school with effect from 31/1/2018, the petitioner was by order dated 17/2/2018 issued by the Director Secondary Education Assam, allowed to hold the charge of the said post of headmaster. Also, thereafter, the cases of the petitioner as well as the respondent number 4 hearing were considered for the purpose of promotion to the said vacant post of headmaster available in the school. Also, on conclusion of the said process of selection, the respondent number 4 was by order dated 9/12/2018 issued by the Director of Secondary Education appointed as the headmaster of the said school in question. So, being agreed, the petition has instituted the present proceedings. Mr. Dr. P.P. Dr. Learned Counsel for the petition, by referring to the provisions of Rule 14 of the Assam Secondary Education Provincialization over Rules 2003, submits that the promotion to the post of headmaster is to be effective basing on the seniority of the candidates in the school and satisfactory ACRs for 3 years. Also, Mr. Doctor, by referring to a list showing the seniority of the teachers available in the precedent, has contended that the petitioner had joined the school on 16/5/89, while the Respondent number 4 had so joined on 29/11/1990. Both the petitioner and the respondent number 4 were authorized their graduate scale of pay with effect from 1/12/1993. Also, it is the contention of Mr. P.P. Doctor that even if the date of receipt of graduate scale in respect of both the petitioner as well as the respondent number 4 is held to be the same, and the services under the intermediate scale of pay is not considered, the only other determinant left for determining their seniority would be the date of birth. Also, referring to the date of birth as revealed, as reflected in the said seniority list, Mr. Dr. submits that the petitioner who was born on 1/1/63 is senior to the respondent number 4 who was born on 1/3/1967. Also, Mr. P.P. Doctor submits that although he was not given to understand as to why he was deprived of a promotion in question, Mr. Doctor, by referring to the revelations made in the affidavit filed by the Director of Secondary Education Assam in the present proceedings, has contended that the petitioner's case for such promotion was rejected by the state level board only on the ground that the petitioner had proceeded to acquire his B.Ed degree without taking permission from the departmental authorities, and further that the institution from where the petitioner had so acquired his B.Ed degree was not an institution recognized by the NCTE. Full stop. Full stop. It is the submission of Mr. Doctor that the respondents having held his B.Ed degree to be invalid and refused the consideration in his case for promotion to the rank to the cadre of to the post of headmaster in as much as now he was held to be ineligible for such promotion. Mr. With regard to the first ground as assigned by the respondent authorities, the pleadings in the present proceeding, Mr. Doctor submits that he has brought on record the permissions granted to him by the respondent authorities for pursuing the said B.Ed course in the evening section. Mr. Doctor submits that the Inspector of Schools wide order dated 4/10/1994 had duly permitted the petitioner to pursue the said course in the evening section without hampering the normal functioning of his school. Also, the said permission was also granted by the headmaster of the school. Headmaster in consultation with the SMDC of the school. Also, in that view of the matter, it is stated that the petitioner had proceeded to undergo the said course by taking due permission from the respondent authority, from the competent authority. Also, it is also submitted by Mr. Doctor that even if there is no permission taken for pursuing the said course, the same would be a misconduct, and the degree as obtained by him being so obtained from a recognized university public college, the said degree cannot be interfered with, and at best only a departmental proceedings under the provisions of the Assam Services Conduct Rules for violation of the provisions of the Assam Services Conduct Rules can be initiated against him. Also, with regard to the second submission, second ground assigned by the respondent, Mr. Doctor submits that the provisions of the NCT Act 1993 had come into force with effect from 1/7/1995, and much prior to the coming into force of the said act, the petitioner was pursuing his course with the Sipachar College. The period during which the petitioner had pursued his B.Ed degree with the in Sipachar College, the said college was not required to get itself recognized from the NCT authorities, in as much as the NCT Act had only come into being with effect from 1/7/1995. Accordingly, the petitioner, having been issued his B.Ed certificate from a recognized university, that is Regarding University, the said degree, the validity of the said degree cannot be questioned by any authority other than the authority issuing such degrees. Mr. Dr. has also brought to the notice of this court that persons similarly situated like him and also who had pursued the B.Ed course during the period when the petitioner had so pursued his said course were considered by the state level selection committee, and their cases were recommended and consequently they were appointed. But in case of the petitioner, a different yardstick came to be applied by the respondent authorities, which violates his rights under Article 14 and 16. Mr. Dr. by referring to the age of the petitioner has contended that the petitioner retired from his services on 31/1/2023 and on reaching the age of superannuation, and it is further contended that his promotion has been illegally deprived to him. This court would pass the appropriate directions to the respondent authorities to promote the petitioner to the post of headmaster of the school with effect from 9/12/2019 with all consequential benefits. It is also submitted by Mr. Dr. that in spite of issuance of the order dated 9/12/2019, the respondent number 4 was not allowed to hold the charge of the post in view of the interim directions passed in the present matter by this court, and he continued to hold the charge of the said post till the date of his superannuation. Next, Mr. M. Nath, learned senior counsel, appearing for the respondent number 5, submits that the petitioner's B.Ed degree having not been obtained from an institution having the NCTE recognition, if such a degree cannot be held to be valid. Also, the provisions of the rules holding the field mandating the possession by a candidate for the post of promotion to the post of headmaster of a valid B.Ed degree, the petitioner's B.Ed degree being so obtained without obtaining prior permission from the respondent authorities and also from an institution not recognized by the NCTE. Full stop. The said degree cannot be held to be valid for the purpose of promotion, and the same cannot be reckoned for considering the case of the petition for promotion to the post of headmaster of the school in question in terms of the provisions of Rule 12 of the rules of 2003. What did he do? So, the petitioner, having not satisfied the eligibility criteria as metted under Rule 12 of the said rules of 2023, the non-consideration of the case of the petitioner has caused no illegality, and the petitioner cannot, as a matter of right, without being eligible, claim for a consideration of his case for promotion to the post of headmaster. It is further submitted by Mr. Nath that the petitioner cannot base his claim for promotion to the post of headmaster solely on the ground of his seniority in this school. Also, on the said premises, Mr. Nath submits that the order dated 9/12/2019 requires no interference, and this court would direct the respondents to grant to the respondent number 4, respondent authorities to grant to the respondent number 4 all benefits flowing to him on account of his said promotion as headmaster with effect from 9/12/2009. Mr. U. Sharma, learned counsel for the respondent, has reiterated the stand taken in the affidavit filed by the respondent number 2 and has also adopted the arguments as advanced by Mr. M. Nath, senior counsel for the respondent number 5. 4. Mr. P.J. Fukan, standing counsel for the respondent university, Guwahati University has submitted that the certificate as issued to the petitioner pertaining to his B.Ed degree has not been cancelled till date by the said university, and the same continues to be in force. Also, I have considered the submissions advanced by the petitioner, by the parties to the proceeding, and also considered the materials available on record. Also, it is at the outset, it is to be noted that this court, by order dated 18/12/2019, while issuing notice in the matter, had directed for maintenance of status quo as on that date with regard to the officiation of the respondent number 4 of the petitioner against the post of headmaster in Dominisuki Girls High School. Full stop. In terms of the said order dated 18/12/2019 passed by this court in the present proceedings, the Director of Secondary Education Assam wide order dated 24/6/2020 had required the maintenance of status quo with regard to the said officiating arrangement against the post of headmaster of the school. Post of the petition, in terms of the said orders, continued to hold the charge of the post of headmaster of the school till the date of his retirement on reaching the age of superannuation with effect from 31/1/2023. Full stop. As evident from the submissions advanced before this court by the learned counsel for the parties, and also the revelations made in the affidavit filed by the respondent number 2, it is seen that the case of the petitioner was rejected. Well, the case of the petitioner was rejected from consideration for promotion to the rank of to the post of headmaster only on the ground that he had obtained his B.Ed degree without departmental permission and had obtained such degree from an institution not recognized by NCT at the relevant point of time. With regard to the objection of the petitioners obtaining his B.Ed degree without permission, this issue is no longer presented, and this court in the case of had already held that the such degree in such circumstances does not get invalidated. It does not get invalidated. Also, the violation, if any, would be of the relevant provision of the Assam Services Conduct Rules 1955 and so and so. And for that, the degree cannot be held to have been invalidated, and the petition may have exposed him for being proceeded against departmentally. Full stop. It is seen that the respondent authorities, although holding that the petitioner had proceeded for the said course without requisite permission, had not instituted any proceeding against him till the date of his superannuation from service. Full stop. This also has to be seen in the light of the materials brought on record by the petitioner, wherein he has demonstrated that he had proceeded for the said selection basing on the permission granted to him, the Inspector of Schools, Tarang District Circle, Mangalore, as well as the principal and the SMDC of the school where he was working. What is also to be noted is that the respondent authorities, after the petitioner had acquired his B.Ed degree, had authorized to him the advance increment as becoming available to him. Also, they said increment as authorized to the petitioner was never thereafter withdrawn, and he continued to enjoy the same till the day of his superannuation. Also, in view of the said conclusion, this court is of the view that in view of the said conclusion, the B.Ed degree of the petitioner cannot be held to be invalid on the said ground of having pursued the same without obtaining due permission from the respondent authorities, which has also in the present case proved to be erroneous inasmuch as the authorities had granted due permission to the petitioner to pursue his said course. Also, now, with regard to the second ground, as raised by the respondent authorities and also urged by Mr. M. Nath, that the petitioner had obtained his B.Ed degree from Sipajar B.Ed College in the year 1995, and at that relevant point of time, the said college was not recognized by NCTE. Also, it is to be noted that the NCT Act 1993 had come into force only with effect from 1/7/1995, and the National Council for Teachers Education, a statutory body, was established only with effect from 17/8/1995. Before the said body could have been established, it is not understood as to how the petition of the respondent authorities can contend that the petitioner was required to pursue his B.Ed course from an organization recognized by NCTE even before the same had come into existence. Also, the degree as pursued by the petitioner in the year 1995 was from an institution which was affiliated by a Guwahati University, and as such, it had a competency to provide the said course in its campus. Also, this coupled with the fact that the petitioner had been granted the advance increment for acquiring the said B.Ed degree shows that at the relevant point of time when the petitioner had acquired the said degree, the same was held to be valid. A degree valid at its initiation cannot be held to have become invalid invalid on grounds which are being now projected and which does not have any nexus to the prosecution by the petitioner at that relevant point of time of his B.Ed degree. Also, in view of the above, the petitioner degree cannot be held to be invalid even on the second ground, and he is held to be eligible for a consideration by the competent authorities for a promotion to the rank to the post of headmaster. Also, having held the petitioner to be eligible, this court would now like to examine the seniority, interstate seniority dispute between the petitioner and the respondent number 4. Also, it is seen that the petitioner had joined in his in the said school on 16/5/1989 after he having acquired his graduation degree. So thereafter, the petitioner was authorized his graduate scale of pay with 1/12/1993. The respondent number 4 had joined the said school again in the intermediate scale of pay on 29/11/1992. As far as the intermediate scale of pay is concerned, the petitioner is admittedly senior to the respondent number 4. Also, however, the respondent number 4 and the petitioner was authorized their graduate scale of pay with effect from 1/12/93, that is on the same day, and accordingly a dispute may arise as to how the seniority of the said two incumbents who have been granted graduate scale on the same day is to be determined. It is to be noted that the seniority for the purpose of promotion to the post of headmaster is then determined from the date a person has drawn his pay in the graduate scale of pay. Also, the said issue did not detain this court inasmuch as the available criteria here would be that the said seniority can be determined on the basis of the date of birth. Also, on examining the date of birth, it is found that the petitioner, while the petitioner was born on 1/6/1963, the respondent number 4 was born on 1/3/1967. As such, the other parameters being equal, the petitioner, on the basis of his date of birth, would rank senior to the respondent number 4. Also, in view of the said conclusions and also the seniority, determination of seniority between the petitioner and the respondent number 4, the impugned order dated 9/12/2019 stands interfered with. So, now this court is to consider as to the relief that can be granted to the petition in the matter. First of all, as noticed herein above, the petitioner continue to hold the charge of the post of headmaster of the school in spite of the fact that the respondent number 7 was promoted to the said post by an order dated 9/12/2024 by virtue of directions passed by this court in the present matter, and the petition accordingly retired from the said post on 31/1/2023 on reaching the age of on retirement on reaching the age of superannuity. Also, the provisions of the 2003 rules, page 363. Page 63. The provisions of Rule 13. Rule 30, no, Rule 15 of the said rules of 2003 mandates that after the names of the eligible candidates are received from each school, the director shall call for the particulars. The director shall place the same before the state selection. It is seen that in the case of the petitioner in the selection held for the post of headmaster between the petitioner and the respondent number 4, the said selection board had rejected the case of the petitioner and had recommended the case of the respondent number 4. Also, the consequential appointment of the respondent number 4 effected by an order dated 9/12/2014 having been interfered by this group, by the present by this group. Also, it is now required that the petitioner's case shall be considered afresh by the state level board or any other competent authority of the secondary education department, and on consideration of the case and examining as to whether the petition fulfill other eligibility criteria, barring the eligibility criteria dealt with herein above in this order, shall proceed to promote the petition as the headmaster of the said school with effect from 9/12/2014. Right? Also, with all consequential benefits, the petitioner shall be entitled to the salaries as due to him against the post of headmaster consequent to his such promotion with effect from 9/12/2019 till the date of his superannuation, that is 31/1/2023. Also, the director of secondary education Assam shall compute the areas of salary due to the petitioner and release it to him in a period of 3 months from the date of receipt of a certified copy of this order. Also, the promotion as now required to be effected in case of the petitioner to the post of the master of the said school would enhance his pay that he had from at the time of his retirement. According the respondent authorities, more particularly the respondent number 2 and the director of pensions shall now recalculate the pension and pensionary benefits of the petitioner and release to the petitioner his arrears thereof within a period of 4 months from the date of receipt of a certified copy of this order. With the above observations and directions, the petition stands disposed of. Everything covered? Recode you need. তাৰমানে কি হৈছিল টিম ওপৰত থৈ দিছিল তো সেইটো মাৰি দিয়াতে কৰি আহি গ'ল এটা বদলাই দিব নিয়ম মই চেঞ্জ কৰি দিম Monday. You can. Yep, okay, yes. Today it may not be possible. I'll fix a date. I'll pass the orders. Possible, I'll pass the orders in chambers. List this matter again on 12/2/2024 for delivery of orders.
Public.
Yes, item number 37. Come on.
Daily list, item 34.
Take it as legal. Yes, Mr. Now you have time. You can proceed.
May it please. My lord, by this petition, I have challenged the validity of the letter order. Dated 15/2003 issued by the respondent number 5 for termination of petitioner being immediately. And the validity of letter and order dated 12/6/2003, placing the petitioner on academic suspension till June.
Yes, Mr. Patti.
Validity of the letter and order dated 12/6/2003 are placing the petitioner on.
You are reading which page, Mr. Patti?
My lord, at page 43, my lord. First of all, I am taking to your lordship to page 37.
40?
37.
37, okay. Yes, I'm marked it, yes.
37.
Hmm.
May I read it, my lord? Dear Mr. Yuvraj Prasad, this is in connection to the incident regarding involvement in the physical and verbal abuse with two security staff at Kemeng Hotel on such and such. As per the report, you were among the PhD students who were involved in physical and verbal abuse of the two security staffs of the institute while they were on duty at Kemeng Hostel on such and such at around such and such. The students' disciplinary committee made on such and such at 3 p.m. Student Affairs Conference House to discuss on the matter. You were given an opportunity to present your case in the meeting when you submitted the statement to the committee, wherein you had admitted regarding your involvement in the accident. Based on the interaction during the meeting held, the SDC found that you had violated several clauses of ordinance on code and conduct of the institute. Now they have related it, my lord. I am skipping over it, my lord. Now next page, my lord. Hence, they undersigned.
Yes, you can proceed.
Hence, the undersigned is to convey that on approval of the competent authority, the following disciplinary action have been initiated against you. Your studency from the being terminated with immediate effect. That was the order, my lord. Then, my lord, I filed the appeal before the board. And
Yes.
on appeal, the order which was passed is at page 43, my lord.
Yes.
43, my lord.
43. Okay.
12/6/2020. May I read it, my lord?
Okay.
This is regarding your appeal against the disciplinary action concerning your involvement in physical and verbal abuse of the two security staffs in Kemeng Hostel on such and such. The board considered your appeal of termination, has cancelled your termination and placed you on academic suspension till June 2024. You are allowed to register from July-November 2024 semester onward with a fine of ₹50,000, which you are directed to visit in IT board, such and such, but no hostel facilities shall be provided for the rest of your PhD program. the fine should be deposited within 10 days. This portion was stated by the Honorable Court regarding the payment of the fine. Within 10 days of the issue declared, and you are to submit the receipt of the payment to the student's avail sanction, email, such and such. My lord, this order has been passed, my lord. My lord, from the first order, your lordship will see that no opportunity of being heard was appropriate to me. And secondly, no grounds have been communicated. How, in what manner I violated the terms and conditions of the ordinance. And secondly, my lord, in second case too, I was not given an opportunity being heard. My lord, prior to coming to the
Mr. When you're making that submission, kindly also deal with that line in that order 37. Second paragraph.
which one, my lord?
Order 37, page 37,
Page 36.
second line, that
Yes.
second paragraph, last line,
Okay.
wherein you had admitted regarding your involvement in the incident. Have you denied this? This
Yes,
finding?
I have explained it. Not specifically I denied, but I explained it.
No, means if you had made this admission before the committee.
Yes, that is there.
Okay.
That is there, my lord. But I explained it, what has happened on that particular day.
Fine.
And for this particular purpose, my lord, may I take your lordship through the paragraph of my disposition. Now, my lord, apart from it, my lord, we were the 5 students.
Huh?
We were the 5 students.
Okay.
4 students were also with me, my lord. In one of the cases, my lord, your lordship will come at page 49. This order has been passed. That the apparent discrimination, my lord. Page 49. This is regarding your appeal against disciplinary action in connection with your involvement in physical and verbal abuse with 2 security staffs and gaming hostel or such and such. The board considered your appeal and your academic suspension reduced to June 2023. My 24, their 23, and all the other punishments, including bail or such and such. And they have been imposed only the fine of rupees 5,000 instead of 50,000. That is it. Apart from it, my lord,
He was also terminated, then June 23.
yes, previously they were terminated. Subsequently, the appeal was allowed
Okay.
and did that one.
Okay.
In respect of 2 students. Now, my lord, I am taking to your lordship to page 48. This is the circular, my lord. This is to inform of all the students that following decisions have been taken by the competent authority with immediate effect. Random visiting of students by security personnel posted near all the institute entrance gates. The security personnel may be posted near the entrance gates. Gate facility gates are authorized to do random visiting of the any student and their belongings while entering the campus. Surprise random visit to the I am concerned with those 2, my lord. Hostel wardens, associate wardens are authorized to make surprise visit to hostel rooms. All students have asked to cooperate. So, my lord, they were not allowed. The security guards were not allowed to enter into the rooms, my lord. And that responsibility was only given to the hostel wardens and associate wardens. And in spite of that, in violation of this circular, my lord, this circular has not been considered at all by them. Now, my lord, I am coming to the first of all certain paragraph of my petition, my lord. Your lordship will come.
Yes.
Para 6, my lord, at page 9. No, it is not so important, my lord. Let us come directly to page 8, my lord. Page 10. That the petitioner begs to state that about 10:30 p.m. on 2/22/2000, the petitioner along with his 4 fellow friends, namely such and such, such and such, such and such, were listening music with very low sound and were having some normal altercations among themselves. Suddenly, two security guards entered the room and started video recording the stunning moment without giving any warning and without the consent of the petitioner and other fellow students. On such unauthorized reaction of the said two security guards, one of the friends of the petitioner, Chandramount Sakya, requested them to stop such video recording. Upon such request, the said security guard pushed him and told by threatening to produce the said video.
The
to the-
next,
But
next, that I got it.
a
Next.
said video to the warden and high officers. Then and there, the petitioner fellow students stopped the video and apologized, requesting them they would not repeat the same again, and accordingly no complaint be made to the warden. Upon such request, next paragraph, my lord, the petitioner begs to say the appointed security guards reported the matter to the warden by producing the videography only of the fighting part of it. Accordingly, the warden ordered the petitioner as well as appointed friends for meeting in the given warden room where the dean of the junior affairs, such and such caretakers, such and such were also present. Based on the video evidence, the petitioner along with the appointed problem were asked to vacate the hostel and campus within 24 hours. This allowing the petitioner friends to be inside the campus until the meeting of the committee SPB has held.
Mr. Bhatti, can I ask you one question? You have referred to page 48 circular, saying that this security guard should not come to the room. They have come. Will that give you a license to use force?
No, that is right, my lord.
That much.
I understand, my lord. But at least they could have informed the warden. As such things.
And after informing the warden had taken the matter forward.
Yes, they could have reported the matter to the warden and warden could have taken the matter.
It's good. At that situation, what happens? We cannot lay down a straitjacket formula for all situations.
That is right, my lord. Now, my lord, your lordship will
Now,
come.
what provoked you to hit them? Why did you hit them?
No, I did not.
Is there a criminal case against these people?
No, personally, I did not.
Criminal case
No.
against the petitioners? No.
No.
My lord, I'm not aware.
Okay, fine.
They would have filed it.
No, my lord. Still, I have no knowledge about it. I have no information or knowledge.
Okay. What is the material now in the inquiry?
Inquiry, my lord, inquiry, they did not conduct the inquiry. What can't they?
No, once you have admitted the charge, what is the necessity of conducting an inquiry?
Inquiry, my lord.
Hmm.
Now, let us come first at inquiry. Later on, I will come on the ordinance, my lord. Provisions of the ordinance. First of all, my lord, they filed the reply, my lord. Your lordship will find the minutes of the meeting held on 22 at page 77.
Page
77.
in the affidavit.
Yeah, they are it.
Okay, sir.
My lord, may I read it? The Dean Students Affairs inquired the concerned student about the physical assault on the security guard, Pankaj Pathak and Ramesh Kupar. The security staff were sent to room of Mr. to
Okay.
collect the liquor bottles. This
Once you have been held that you were intoxicated, was any medical examination carried?
No. Now, my lord, this one, next one, my lord. At page 81.
Okay.
That is, in fact, the order which has been passed. But that was not supplied to me at the initial stage, my lord. As your lordship has already gone through, annexure A, my lord. As per the email received, my lord, directly I am taking to your lordship.
You had referred to one page 49. What is the name of that boy?
Yes, those names.
Mahendra Patel, man.
Huh?
Mahendra Patel.
Mahendra Patel. Okay.
Now, my lord, I am taking page 82 from para 2.
I've got it.
The wardens and dean students affairs section, upon reaching the hostel, found that the security guards were badly hurt and were sent to the hospital. My lord, nothing has been indicated to which of the hospitals they were sent and what kind of treatment was given to them. The students were drunk except Chandramohan's Raja. On the student Yuvraj was so drunk that he was shouting and his friends had to intervene to stop him from shouting in front of the other officials. He mentioned that even if he is terminated, he is fine, but security guards cannot do this with students. The reason of the assault was understood to be that the security guards asked them to stop the music at the time when they were drinking in the hostel room. All of them started to argue with the security and finally they assaulted the security staff. The entire episode was captured in a video by another student from the opposite balcony without anyone's knowledge. Given the severity of the accident deal, my lord, so far this video is concerned, that has not been given, the copy thereof was not supplied to me. And further, they have also not produced before this honorable court. Given the severity of the accident, Dean Student Affairs section, along with the hostel wardens, general secretaries, along with other officials, held a meeting the same night and decided to expel the student from the hostel till SDG meets and takes the final decision. The letter was issued the same night from the hostel office. The students have been asked not to be seen on campus. They cannot come to their labs as well. They were asked to vacate the hostel 24 hours by such and such day. Although a written statement is
It's fine, Mr. You need not go there.
so this being and initially it was not accordingly I filed the affidavit in opposition my lord. I have denied and clarified the statements.
Why this Mahendra Patel was given a lower?
My lord, that part, my lord, will find in the report itself. It's, but I'll take it through, my lord.
But just
He was-
Mahendra Patel, page 86.
Yes, my lord. He was not found hitting them, my lord. Specifically mentioned. Let me read, if the my lord wants, then I'll read it out.
No.
The students who beat up the security, page 83, my lord, if my lord is with me. 83, para number 1.
Just a moment, just a moment.
In between, my lord, it is recorded.
Okay.
It is not only one, my lord. 2 people were not found physically assaulting the security guards. That is Vivek and Mahendra Patel.
Vivek means Vivek.
Vivek Kumar, my lord.
In whose whom they had.
My lord.
Got it.
My lord will, with regard to Vivek, my lord, my lord is fine, will find in page number 85, my lord. Point number 4.
Okay.
Same punishment as Mahendra Patel.
5. 84, 5.
84.
5. Vivek Kumar. Yes.
85, 4, my lord.
85, 4.
4 is Vivek Kumar punishment with regard to Vivek Kumar.
Okay.
Bottom, my lord.
He was given a further reduced one.
He was not found.
December. And
Yeah.
the other one, they
Same
got
thing, my
till
lord.
June.
December.
After.
Mahendra Patel and Vivek Kumar were not found in assaulting.
No. After the appeal, these two were given.
Their punishment were not reduced, my lord. Same punishment remained for them.
No, the Patel has been reduced till June. And the amount is 5,000.
Yeah.
Amount, BOG, my lord, that BOG minute will find at page number, my lord, 88. I think that it was proposed only this, my lord. Huh? 89. No, it was only. That I think, my lord, was not properly recorded. I think 86 clarifies it. This
Page
punishment was,
89 says,
my lord.
page 89.
Yes, my lord. But if that, I think, my lord, is some error in A. 86, the
Now, what was
punishment,
the final penalty given to him? 50,000?
50,000, my lord.
June 2022.
Yes, my lord. That is, my lord, will allow me, I'll show that he himself in the appeal has stated that we are ready to reimburse.
No, that's
That specific pleading is there, my lord, in the appeal memo itself. They admitted to everything in the appeal memo. Page 41, my lord, will see.
How old are these guys? This, how old are they?
These are all PhD students at page number, my lord. It's from 80, I can guess, I can gather, my lord, that these are all PhD students.
Okay.
Page number 80, my lord. Some is of third year, some is of.
Yes, Mr. Bhatti, what is the error? According to you,
According to me, my lord,
point wise.
the punishment given, my lord, is
Hmm.
severe,
Punishment given is
very serious. It is not proportionate
disproportionate.
and disproportionate. And apart from it, it is also discriminate. My other fellows have been given only the 5,000 and up to 23 December. And December I already passed, my lord.
And no parity has been maintained.
Yes. Second, my lord, no sufficient opportunity was given to me.
Where is that plea of yours in before the authorities?
Yes, in my pleading, I have taken that.
No. In the appeal.
Appeal, my lord, so far the appeal memo.
Oh.
Just a minute, my lord, I will go. It
Page
was not
39.
it was not taken specifically, my lord.
Then
But even
that-
though, my lord.
when Mr.
even-
Bhatti comes in,
my-
all those
my-
grounds
my
would come in.
Even though.
And
But-
see, they have not even denied that incident, Mr. Bhatti. That's what
Yes,
I'm.
that is that, my lord, but it is no so serious incident. Apart from it, my lord, may I take your lordship to certain provisions of the ordinance, my lord, where
Page 41,
yes, yes,
humble request.
yes, that is because they are laymen, my lord. Even though they are well educated, but so far this line is concerned, my lord, go. They are laymen.
Okay, 2 points. Then,
Then in appeal to, my lord, I was.
no,
not
these
given-
are the 2 points.
Ah,
Punishment
I was not
disproportionate and
given-
no parity has been maintained.
Yes.
Next,
Secondly, my lord, I was not given the opportunity to cross-examine the witnesses, my lord. These two fellows, I was not given the opportunity to cross-examine them.
that means the security guards.
The security guards, my lord. And they were also not examined
In
by
the inquiry.
them, but they consulted it over telephone. So all these infirmities are there, my lord.
Okay, fine. Then what is more? Now, without their examination, in the light of your admission that you had bashed them up, what prejudice was caused to you?
That aspect,
No,
my
that has to be
because,
gone
my
into.
lord, it depends upon the wrongful entry of the security guards. my lord.
Fine,
Your lordship has already gone through.
Mr. Bhatti, I agree with that. But you have not,
Yes,
you have,
but
you
my
have,
lord,
don't have the
my
license to
case
beat
is
people.
specific that
The students.
I was not there to beat them. It is not my specific pleading.
No. In the writ petition, forget it. Show me in the proceedings where you have said, rather you are trying to justify the beating.
No,
Yes.
that
You
is
come to your appeal.
that is their recording, my lord.
That's what I
That-
want to hear from you.
Yes, because
Page 39,
I have denied it, page 39.
40.
40. All right.
When we reach the ground floor, first paragraph, the second paragraph, brief explanation. They started abusing, pushing us, which led to the physical confrontation. Someone recorded the last moment of the incident in which Only that fighting part was visible. Before that, however, a lot had happened. Now, you should have moved immediately to the warden, complained. See, sir, this is what is happening. What gave you the power to take law into your hands?
No, that is right. That, to that extent, I agree, my lord. That I did not go to the warden, I did not report it, but I was not there to beat them.
No, you are there. It's there. Page 39.
Page 35.
39, 40.
40, which paragraph, my lord?
40 brief explanation starts.
Last line.
Sometimes,
Last line.
First paragraph.
according to the mail.
No, sir. Brief explanation. The paragraph next, last line of that. First paragraph. Brief explanation. And see also the second line. Third paragraph, second line. It is one spontaneous event. It's not that something happened 1 hour afterwards, something happened. It came. No, you have taken the concept B of disproportionality. That is what I'm trying to examine. That's all. So nothing is here that you were not allowed to cross.
Apart from it, my lord, so far the violation of religious justice is concerned, my lord, I was not given the chance to cross-examine them. They have not examined personally. They have not examined personally.
No. What prejudice was caused you after your such statement? That non-examination of those witnesses caused you prejudice. You have not taken that plea.
No, that in appeal memo I have not taken, as earlier I pointed out, my lord.
No.
That is-
Okay, fine. Even an indication that because of these people not being there, you had never gone on that line. You had gone giving clarifications that it happened. We bait him. Khatam. That's the end of the matter.
That is their.
Mr. Bhatti, you will have to show me prejudice. Prejudice.
My lord, only that my
Need
equal.
not. What prejudice, what difference would have caused if you had examined those two people? I think it would have been worse.
Only disproportionate.
You have not yet brought your case within that because Mr. Day says that the other two were given a lower punishment because of their extent of involvement.
My lord, directly I was also not involved in. beating
No, you
another
have
person.
not said that, Mr. That's the problem
Yes,
I'm
sir,
facing.
in a memo, appeal of memo, I have not said.
Not
it
even
is
appeal
so-
memo.
so-
That's why first question I pointed out to you. Page,
In so
if you
many.
come to page 37. First question that I asked you. Page 37. You were given an opportunity to present your case in the meeting when it is submitted a statement to the committee. Where is the statement of this?
My lord, I have all records I have given. And along with that, my lord, I had given the video evidence last time, my lord.
Records can you put here? Records can you see? You moved orders. Fine. I'll do it. I sleep right?
My lord, can look into para number 80, page number 84 for a
You
moment.
had
and
given original records or Xerox?
Xerox had given to the my lords. Along with my written,
This one?
my lord, maybe. Check
This one?
now.
This one?
Check one now.
Today you have given.
No, my lord.
Last one, yes, you had given, I know. Is this the one, see?
My lord, apart from this, his statement, his co-accused is admitted of the offense, my lord. Page number 84.
When? Okay, where is that statement of the petitioner?
My lord, before going there for a moment, my lord. So the SDC proceedings had taken place in two portions. First, there were individually been heard. So oral submissions were been made by them. Then they were asked to write in an EA, make the written submissions.
Okay, Yuvraj Siddharth. dated 24/2/22. Purely accidental fight. And 2 guards hospitalized. Okay, then what do you have to show me?
My lord, can look into page number 84 of my affidavit for a moment. My lord, I'll not trouble with the records if my lord will permit. Page number 84, my lord, in the Vidyabhushan's CA, where he records, as per his statement, he and his friends went to Brahmaputra Ghat around at 6:30 p.m., where they had alcohol. At 9:45 p.m., when they went to Yuvraj's room, where they were listening to music, when security staff started taking video of them. On stopping of them from taking video, security misbehaved with them, pushed and threatened. He stopped in the first
Your
floor.
courses start from June.
My lord?
Your courses start from June.
Yes, my lord.
June to June.
My lord, I will, if 2 minutes I can give a call and find out, my lord.
June 23.
It starts.
Yeah.
No. The course when it starts.
No,
Okay.
it started now. The semester is
If
You,
my lord will give
Mr.
me 2 minutes,
Mr.
I'll find
Bhatt,
out.
January to June.
January. You satisfy me on this 2 points. Prejudice cost to you because of non-examination, how will it have affected the proceedings? And your admission. How do this court look into it? These 2 points you satisfy me. Boys, we will do something. But these 2 points are troubling. Give me judgments.
Let it come any other day.
Fine, no problem.
On 8th.
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 My lord, may not be on, my lord, may it be on the next week, my lord, please. I have something on this.
No, 8th, he said. 8th, you don't have, you have some problem.
My lord,
13th.
can it be on 12th, my lord, if it is
13th.
convenient to this.
13th.
Otherwise, yes, my lord.
Mr. Bhatti, you need not keep on waiting the whole day. At 2 o'clock morning, just ask your junior to mention. I'll take it up at 2. But I want those judgments.
All right.
Because the material that has come on record is against you and you have not denied it. That's the problem I have just. I'm keeping this. You can take this back. You can give it to me on that. Oh, I'll keep it.
My lord, I have also given my written submissions and the pictures with the.
It is there with me.
Video evidence I had produced before the Lord on that day. My lord,
I did not.
Yes, my lord had asked if the petitioner wants to see. I am there, my lord. They can come to my chambers and they can look at the
Mr.
video.
Bhatti will not be prejudiced. He is open now.
My lord is 16th, 13th, my lord.
It is 13 too.
13th.
Oh, you want it? Yes, Mr. Bachchaji. Chakraborty, come.
Lordship, I checked out.
Huh?
Paper publication is necessary, Lordship.
Then?
Notwithstanding that, the BTC people are saying that everything is fair. That communication I have annexed. But I have checked out, Lordship, paper publication is necessary.
Must. Mamta ma'am want it.
Section 3, Lordship.
And that rules also say that.
Rules.
So, this cannot be. Nothing is it. And
In view of that, I can't say
even
anything
that.
more. But the BTC people are saying that
Forget
everything
PTC.
is okay, fair.
This court orders plus the stand before this court that we have cancelled in the writ proceedings. I just went through, I got it. So you withdraw it on the prayer of Mr. P. Chakraborty, Learned Counsel for the petition submits on instructions that the petitioners desires not to.
Also, what is
This.
that? Lordship, that they put in difficulty. In view of the section, Lordship may quote that.
Okay.
Otherwise, they may say, I haven't
Okay,
given you
okay.
instructions.
You're referring to that education, that elementary education.
Elementary rule, 1977 rule.
So, in view of the requirement under the Assam Elementary Education Bracketed Provincialized Rules 1977 for a paper publication
Rule
in
3, Lordship.
for publication of an advertisement in the newspapers inviting applications for the posts covered by the said rules.
An advertisement is issued by the director.
Fine. In terms of that. the advertisement as brought on record by way of this review petition is only a notification for advertisement and not the advertisement published in the newspapers in terms of the provisions of Rule 3 of the said rules of 1977. Post with this said situation, Mr. Chakraborty submits that he may be permitted to withdraw the present petition. Accordingly, the review petition stands dismissed. You prefer an appeal if you want against that order.
If something find out later on.
Thank you.
Item 35.
It's regarding the post of secretary. Secretary Gaon Panchayat.
What idea?
Physically handicapped person, Miller.
Yes.
Secretary Gaon Panchayat, Miller. He has not been regularized. His colleagues have been regularized. Since he is a physically handicapped person, Miller, his name has been.
Yes, Mr.
My lord, my verbal instruction is that, my lord, petitioner is not getting the fixed pay salary, minimum pay.
Why?
Because his case was for regularization, my lord. So as per Opendas, he is not getting the minimum pay scale, my lord. So, and one problem is there, my lord. As finance department may have some difficulty with this, my lord. Finance department is not a party in this case. Otherwise, our affidavits are not objecting the case of the petitioner. And the affidavit filed by the respondent number 2 is irrelevant, my
lord. When have you fixed that 311 matter?
Lord, judgment has been reserved.
Reserved. Okay. That's why they filed.
It is not against finance department, Lord. Panchayat and rural development.
Yes, you get your written instructions.
Section 33.
But I'll not, 2013, I'll not.
Already affidavit has been filed, but affidavits are not supporting the, to defend.
I wanted your records for that.
My lord.
Affidavits are clear.
And finance is
essential. In my favor. His name has been excluded since his name has not been forwarded by the.
Yes,
when do you want it? Mr. Doctor, when do you want it?
My lord.
Because if something can be done for this person.
My lord.
This
only finance department, that is our problem. A finance department is not a party here. They may have object.
Forget it.
My lord.
You give a copy to Mr. Ogugwe.
My lord.
Whatever is there, I will not improve. But
my
when can you have your instructions? Written instructions.
Written instruction, lordship. 12 to 16, I am not available, my lord. Either before that or after that.
Before that, not possible.
After 19 onwards, my lord.
26 to 22. On the prayer of Mr. S. Dr. Standing Council, Panchayat and Rural Development Department lists this matter again on
27
to 2024, on which date he shall place on record the instructions as directed by this court in the earlier orders.
The lordship may also observe that I will serve a copy to the finance department.
No need, no need.
Otherwise, they will not.
We'll see if it comes, we'll see.
My lord.
Most of this.
I love you.
Thank you.
Hello.
Typo.